Has happened, my lord, on 28 August 2024. My lord, your lordship was pleased to confirm a sale in the instance of the AGOT West Bengal in respect of the land property situated at.
The sale by this court.
Yes, yes, yes. I have the order.
Which matter?
Matter, my lord, AGA number the 1 of 2024. Kindly see the order. Contact with the guy. Yeah, sure. Just a minute. Then what has happened, my lord? There is a time limit of 1 month that has not been executed, my lord. No registration, nothing has been paid. Now, my lord, we are willing to purchase the property, my lord, with higher price. If the proceedings is not stayed, my lord, then
Yes, then what?
nothing has been done. No registration, nothing payment. My information is that. And now, my lord, I am willing to, my lord, purchase.
No, sorry. Come after vacation.
If the proceedings is not in the meantime, my lord,
Sorry,
then,
sir.
my lord, let the matter be, my lord. Then, my lord.
Yes, next.
Can you accept the mention in, let it be appear after vacation, my lord.
May I have my lord's kind?
Come after
My lord.
vacation, mention.
My lord, may be permitted to mention, my lord, an application, my lord, where I am seeking leave to, my lord, affirm the application and file it with short cause title. My lord, I declared it as an undefended suit, my lord, on 20th November. It was fixed on 18th at 3 p.m. It was not taken up because of the resolution, my lord. But I am only seeking leave to file it in the department. That's all. My lord, this is for me to enter appearance and, my lord, contest the suit by filing written statement. Non-commercial suit. I have only come to learn that upon a paper publication being made that the suit is there, my lord. Thereafter, my lord, it's been declared as
in the department.
my lord, that leave, my lord, without my filing this application, my lord, I won't be able to file it, my lord. I don't have the full cause title of the plaint. I don't have a copy of the plaint. There was paper publication directed in this matter, so I have not been served. And my lord has recorded in my lord's order of 20th November that no writ of summons was served. My lord, will kindly have a look. Kindly have a look at. No writ of summons was served on me, so my lord had directed paper publication. So I don't have a copy of the plaint, so I don't have the full cause title, my lord. Only seeking leave to file with short cause title.
Undefended suit.
Yes, my lord, I am the defendant, my lord. I don't have a copy of the plaint. I'm only seeking to file this application. My lord will pass whatever orders, my lord, short cost.
May I have my lord's kind
It
leave?
is granted to file the application which cost sorted.
Oblige, my lord.
May I have my lord's kind leave to mention a commercial suit? Your lordship had mentioned this suit on Tuesday. Upon mentioning, your lordship had directed the suit to appear on today for withdrawal, your lordship. The matter has been settled. We'll file a terms of settlement. I'm mentioning upon notice, Miss Kundalia was appearing. She's in some personal difficulty today. So your lordship may direct it to appear on Monday, your lordship. Just for withdrawal.
Not appearing today.
No, your lordship. It's not appearing
Why?
today. I had given a slip on Tuesday also, your lordship.
No, if the court has directed to appear today, why it is not appeared today?
Great. May I be
It is the matter on Monday.
May I be permitted to mention another probate matter, your lordship, for correction of the order dated 17th December 2024. Your lordship, there's a line which has to be added, your lordship. If this could appear on Monday, has to be mentioned.
Monday is non-commercial. Commercial midday.
Um,
What is the correction?
I'll indicate to your lordship.
Yes.
Your lordship, 10 lines from the top, where it starts as counsel for the petitioner submits that the wife of the testator has filed her affidavit of consent, stating that she has no objection for grant of probate of the will to the petitioner, but the other 3 legal heirs, instead of 3, your lordship, it will be 2 legal heirs, and have neither filed affidavit of consent nor have filed in the affidavit in support. There has to be a line has to be added, your lordship. One of the heirs have filed their affidavit of consent, your lordship.
Leave.
If this could be corrected, your lordship.
After vacation, correction.
Lord, may I have your lordship's leave to mention, my lord,
Well,
seeking leave to file written statement after the period of 38 days, which was mentioned in the written sum, but
Commercial.
commercial, but within the 120 days, my lord. I have filed an application seeking extension on 19th of December, my lord. The time to file written statement 120 days expires on 26th of December, my lord. I was only praying for leave. If
Have you already filed application?
it's already filed, my lord, 19th of December.
Leave is granted to file the affirmed.
My lord, yes, my
Written
lord.
statement is affirmed.
Affirmed, my lord.
Leave is granted to file the written statement in the department subject to acceptance by this court.
Grateful, my lord.
My lord, may I have my
In
lord's
course of the day,
my lord, may I have my lord's kind leave to mention on commercial matter item number 65. It's appearing in my lord's list. I'm mentioning upon notice.
I appeal for the plaintiff.
My lord, I am appearing on behalf of the defendant. My lord, the written statement is of
65.
65, my lord. It's Mystery Lal Minings versus Coronation Infrastructure.
Hmm.
My lord, I am seeking leave to file the written statement, my lord. It's affirmed. It's ready. I have taken out an application, but that could not be filed because the clear 4.
How many days?
Today is the 128th day, but it's affirmed yesterday. In the 119th day, it has been affirmed. So it's otherwise everything is ready. All formality is done, my lord. I need leave for my lord to file the same.
Liberty is granted to file the written statement in course of the day subject to acceptance. Liberty is granted to file the written statement in course of the day subject to acceptance by the
Grateful, my
Lordship, passing formal order to that effect.
lord. Leave.
They are in the lead. Grateful.
Grateful, my lord.
Yes, call the list.
Lord, I had mentioned this, not it's a parted matter, not for not fixing, not sometimes, Mr. Sai Deepak is appearing not from Delhi, not his request, not if it could be not fixed, our auditor say. Not on 6th of February, my lord, or 14th, 20th, not any day convenient, your lordship, not as well. And my lord, this has not been spoken to the other side, but they have also no difficulty on these dates. Subject to my lord's pleasure. Time. Yes.
It has not appeared in 20.
Today's 20th.
Okay, today.
It was, yes.
Do we mention?
Well, because I had mentioned, well, because it was not appearing at the bottom, Lord, and Lord, he was to come from Delhi, Lord, if in case it was not taken up. So that is why I'm not date request for fixing a date and time, Lord.
So what you want?
Lord, on if it could be not fixed, Lord, on 6th or 14th or 20th, Lord,
February.
February.
February. 6 February है
14th February.
14th. What time? 14th February.
Very good. Grateful.
So appearing for the suit appeal.
Lord, appeal.
Is the appeal.
Yes, Lord, appeal. Let us present.
So appearing for the appealant. So
Lord, let us
appearing for the
present.
respondent. Full stop. The counsel for the party submitted. The matter was heard in part and praying for fixing the matter on a specific date and time. But the counsel for the respective parties, let the matter appear on 14th of February 2025 at 2 p.m.
Very grateful, Lordship.
My lord, in this matter, I am for the petitioner, my lord. My lord, in this matter, my lord, my client does not want to proceed this matter, my lord. As per his instruction, my lord, I praying for withdrawal of this suit and also praying for reimbursement of the court fee, my lord. And here is the letter, my lord.
When the suit was filed, 2021.
Yes, my lord.
Now, now the court can reimburse the court fee.
My lord, this is my humble submission, my lord. Kindly, my lord. Kindly allow, my lord.
Last question you have asked for the written
instruction
Ah.
from the client. So
Lordship, repeatedly the matter was appearing on the last 4 occasions. They chose not to appear. It was only when Lordship had peremptorily directed inspection and discovery, and Lordship, they have appeared now. And on the last occasion, they wanted to withdraw without any written instructions. Lordship told them to come up with written instructions. They have come up with written
my lord,
instructions.
every document has been already showcased, my lord.
Okay.
Kindly allow my prayer, my lord, for reimbursement of the court fee, my lord. Kindly.
For the plaintiff, when suffering for the defendant, counsel for the plaintiff handed over a communication made by the plaintiff to the learned advocate on record of the plaintiff, informing that the plaintiff do not intend to proceed the matter further and instructed the learned counsel to withdraw the suit. In terms of the communication dated 19/12/2024, the learned counsel for the plaintiff prays for withdrawal of the suit. The counsel for the plaintiff further submit that she may be allowed to take direction will be issued for refund of the court fee paid by the plaintiff at the time of filing of the suit. Full stop. Counsel for the defendant raised objection and submitted that he has no objection if the suit is withdrawn. But regarding refund of the court fee, he submitted that the matter was filed in the 2021. Subsequently, several occasions the plaintiff has not appeared, and subsequently this court has passed an order for discovery and inspection. Now the plaintiff has filed and submit before this court for withdrawal of the suit. Heard the learned counsel for the respective parties perused the communication dated 19/12/2024 and the submission made by the counsel for submission made by the counsel for the respective parties. Full stop. CS Com 267 of 2024 with the packet old CS number 92 of 2021 is dismissed as withdrawn. Full stop. Communication filed by the plaintiff be kept with the record. As regard the refund of fee, this court find that the suit was filed in the 2021. Several orders have been passed, and as such, this is not the proper case for passing an order for refund of the court fee.
So on the contrary, I would be asking for paying for cost.
Grateful, my lord.
Yes, next.
Item number 3, my lord, I appear for the plaintiff.
For the other
I appear for the defendant number 1.
one, who is for the 45 number 2? No, I have dictated the order in open court, but while I'm correcting the orders, I find that some further clarification is required because they have cited several judgments
My lord,
and 2 agreements. First,
my lord,
2018 and then 2021.
my lord.
Thereafter, you have rely upon the completion certificate.
Yes.
In the completion certificate, there is a clause.
My lord,
There is a clause. It is subject to further. There is
my
a
lord,
clause.
my lord.
Correct. And
My lord.
third is there the second agreement which they are telling that you are
With a joint venture.
joint
Yes,
venture.
yes,
In that they are telling that if any due is there, they can realize that.
my
So
lord.
that has not been
My lord,
properly.
our submission and Mr. Chaudhury's submission, he's leading me in the matter, my lord. Submission was
Now,
that
what
no,
I propose,
my lord.
what I propose, instead of I am fixing a further parted matter after the
My lord.
vacation, so that proper opportunity should be given, then I can pass. an
My
order. So that's why I not pass the order.
No difficulty, my lord.
That order will not be there.
No,
Yes.
that order will not be there. I will fix as a parted. I will record the order. I heard in the court, I dictated the order, but at the time of passing the judgment, correcting the order, this court find that this has not been properly given the clarification as being given the parties.
Mulad
And
can, if it commences to Mulad can fix it for only for clarification. Mulad has already decided upon it to a degree for clarification. If
and the
Mulad fixes,
judgments you are not.
Mulad, the judgments, Mulad, all of them mostly accepted.
Come,
If-
I'm very opening
Mulad,
my
for
case.
clarification, if Mulad keeps it instead of it being heard afresh.
My lord, in the manner my lord has
Lordship will only take note of the fact that the bank has made the deposit, kept it in a.
Not that the bank was not there. It was-
Bank was there.
it is to appear on
On the
Monday.
last date, I think
No, it's not there.
I was not there.
Yes, what you are
This
giving.
is the bank has kept it in a separate term deposit
That,
account. So just I'm bringing.
so and so in the matter is listed as to be mentioned
Yes.
as per the direction passed by this court. The matter was heard by this court on date दे देगा मेरा on last order में heard by this court, and in open court this court has dictated the order, but at the time of correction of the order dictated by this court in the open court, this court find that several points raised by the defendant in the application has not been properly explained either by the plaintiff or the defendant, and thus this court is of the view that further hearing should be given to the parties for proper adjudication of the matter, and thus the order which has been dictated by this court has not been treated as a final order. Let the matter be fixed as a part heard on, give the date, January 1st week.
No, it can be at 3:45. I don't think Mr. Chaudhary will take too much time.
कितने बजे 3 है 3 p.m. 11 no
Theory.
January I am asking. Let the matter appear on, this is a commercial matter.
It's a
Yes,
commercial
my lord.
matter.
Let the matter appear on 10th of January 2025 at 12 noon.
Obliged.
One prayer, my lord. We are filing an application for extension for filing written statement.
That you
It's within 120 days, my lord.
My lord
If
had
my lord-
made the main
have you
matter.
filed the written statement?
Not filed, my lord. It's ready, my lord.
If you file, then come, I will see to that.
My lord, there's one.
The counsel for the defendant number 1 has filed the document showing that the amount deposited by the defendant number 2 kept in the separate account. Let the same be kept with the record.
My lord, so my lord, the returnable date that my lord had dictated, that's 23rd December. That day, my lord, the matter won't be taken up.
Suit
23rd
is
December?
fixed on
Suit is fixed on
23rd Monday. It will appear, my lord.
Obliged.
Great.
Obliged.
Already instruction file for the HLM mentioned.
This
I can do the charge delivery now.
connected J is also displayed.
Lordship, this is appearing at my instance. We
Yes.
had mentioned the instructions were along with the mentioning slip, the entire claim due is satisfied.
Hmm.
So, my lord, will you withdraw? It was a part of the mentioning notice and the slip handed over. My lord, this is an office copy. Kindly excuse of.
Kindly excuse me.
Yes. Do not proceed in the aforesaid caption. We settle the same. You are
Extremely
for the
bad for
plaintiff.
us.
Yes,
Both are plaintiff.
Both are playing extremely bad for us.
this suit, my lord, did not suit us.
So and so appearing for the plaintiff, so and so appearing for the defendant, and so and so appearing for the plaintiff. The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff on the ground that the matter has been settled between the parties. When the matter is taken up today, the counsel for the plaintiff submit that they have received the written instruction by email dated 18th of December 2024, wherein the plaintiff has informed the learned advocate on record of the plaintiff that the matter has been settled between the parties out of the court, and the plaintiff do not want to proceed with the case and requested the learned advocate to withdraw the case. In view of the submission made by the counsel for the plaintiff and the communication dated 18th December 2024, CS Com 799 of 2024 is dismissed as withdrawn. Full stop. Consequently, all pending applications are also dismissed.
There was an interim order as
The
well.
matter, if any, stand vacated.
Extremely
The
obliged.
communication be kept with the record.
5,000 rupees extra paid by the other side.
For mentioning.
Extremely obliged.
Yes.
Well, these were for correction
Hmm.
of defects that have come up in scrutiny.
What is the correction?
And the specific government as to dispensation of clause 12.
Where? Now, what is your prayer? What is your prayer? What is your prayer?
Well, like in the main suit,
Ah,
goods sold and delivered, Miller.
what you want?
A decree for a sum of rupees 14 lakhs. Calculation is given in paragraph 13.
14 lakh 9,088.
Yes, Miller. The
What is the prayer now?
the correction, my lord.
Which correction? What correction you want?
I'll just point out. Para 18. Yes, my lord. The correction is in para 18, my lord.
Para?
18.
1-8.
Yes, my lord. On page 9.
Ah.
No, the department says that there has to be a specific government saying that dispensation, and thus the plaintiff prays for a dispensation of clause 12 of the listener. The prayer already mentions it, but that has come up in scrutiny, my lord.
Dispensation of?
Clause 12, leave under clause 12.
You're not prayed for.
My lord, it is prayed in the prayer mentions it, my lord.
Huh?
The prayer mentions it, my lord, on page
Then
10.
This is a GA.
Not the G in the
Is
in
a
the plaint,
GA.
my lord.
Huh?
The plaint are in. I mean,
Plaint আছে কি?
scrutiny.
Plaint hai? Plaint? What is for the GA?
These are injunction applications, my lord.
The GA has come.
But this is under to
In
be
the GA
mentioned.
you are annexed a plaint.
Yes, my lord.
Which page?
My lord, page 86.
Clause 12 of the letters patent.
Yes, my lord.
Ah. So, paragraph 18.
My lord, the correction will be on page. Correction is on page 94. No, the correction will be on page 94. My lord. The equivalent portion of page 94 in the plain, my lord.
So appearing for the plaintiff. Counsel for the plaintiff submitted. The leave was granted.
Yes, my lord. That on the 25th of November, my lord.
Counsel for the plaintiff submitted. This court has granted leave under clause 12 of the letters patent by an order dated
25th November, my lord.
6th of November 2024, and the plaint was admitted. Subject to scrutiny. Counsel for the plaintiff submitted at the time of scrutiny, the department has pointed out to the learned advocate on record of the plaintiff that though the plaintiff has mentioned in paragraph 18 of the plaint about the cause of action within and outside of this court, but has not mentioned the sentence for leave under clause 12 of the letters patent. Accordingly, plaintiff is granted leave. But there are other defects are there, so
Yes, my lord.
altogether 7 defects are there.
I'll rectify them one by one, my lord.
No.
Leave is required only for the.
Once the court has already passed, then you have to file an application. Typographical error in the address also. Page 34 plaint is illegible. Order 9 rule 6.3 not proper. Annexes are to be punched.
Lord, these corrections will be made, my lord.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. The plaintiff submits that though this court by an order dated 28 November 2024 has granted leave under clause 12 of the letters patent, but at the time of scrutiny, the department has pointed out, defendant has informed the learned advocate of the plaintiff that the defendant and the plaintiff has not made any averment in the plaint in the plaint for leave under clause 12 of the latest patent. Full stop. The department has submitted the section officer attached to the London master has submitted the report wherein it is found that there are altogether 7 defects are appearing in the plaint, including non-disclosure of the averment with regard to averment in the plaint with regard to leave under clause 12. Accordingly, this could not find that the same can be cured by oral prayer of the plaintiff. Accordingly, plaintiff is given liberty to take appropriate steps if any required. Next.
Very well. Milord, similar premises, Milord, similar application, similar.
Same.
Yes, Milord.
Same order.
Item 6 No, 5 RSD আমি মেনশন করেছিলাম ফর কারেকশন আমার প্লেন্টের স্ক্রুটিনি
Item 6 is only for correction.
Yes.
Yes.
Milord, item 7. Milord, I think by mistake it is appearing as for correction. My lord had already corrected the order on 16th, Monday. My lord, it was due to appear anyway, Milord, as for new motion, Milord, after service. My lord had injuncted the Milord passed an order restraining the bank guarantee to be invoked on 9th of this month. Now, Milord, we have served Milord both by hard copy and Milord by the soft copy, Milord, both. Milord, that is also ready. My lord, Milord, the interim order is still 24th. My lord, will extend the interim order
23rd.
Let it come on 24. Though the matter is listed as to be mentioned for correction, but it is found that the court has passed an order for correction by the order date. When it was passed?
9th December.
For correction.
For correction, it was on 16th December, Lordship.
16th of December 2020. It is fine from the record. The matter is already fixed. 24th of December.
Lordship, no, this is fixed today, Your Lordship. If you Lordship kindly look into the order date December. The order is still 23rd.
Is the matter on 20? Why? कौन बनाता है लिस्ट? क्यों टू बी मेंशन? मैटर जब ऑर्डर देते हैं तो लिस्ट में नहीं आता है, डेट होता है तो टू बी मेंशन में आता है. Why? Who is preparing?
the new motion. Only the heading
रहता है, GNE ऑर्डर रहता है. क्या हो क्या रहा है कोर्ट में? What is going on? Let the court be closed. If all persons will get the time, then the court will sit. Suffering for the plaintiff. Full stop. It is fine from the cause list. The matter is listed under the heading to be mentioned for, but it correction in the order dated 9th of December 2024 has already been carried out. But as per the order dated 9th of December 2024, the matter is to be listed as new motion today. But and inadvertently it has been listed as to be mentioned for correction. It is fine from the record. The passed by this is 23rd of December 2025. List the matter on 23rd of December 2025 under the heading new motion. The affidavit of service filed by the next.
My lords, I appear for the plaintiff. This is a suit for recovery of excess money paid for the purchase of dry red chilies. My lord, I'm craving leave under clause 12 of the letters patent. My lord, part cause of action is outside the jurisdiction of this honorable court. Even the defendant resides outside the jurisdiction of this honorable court. Payments have been made within the jurisdiction, but the supplies have been made from outside the jurisdiction of the honorable court.
What has it made?
payments have been made from the within the jurisdiction, but the supplies have been made outside the jurisdiction of this honorable court.
Where the payment is made? Where is the document? Payment is made within the jurisdiction, madam.
My lords, kindly takes page number.
Through bank.
No, my lords, I'm a purchaser of supply.
Through bank, it was.
Yes, my
payment
lords.
was made.
Yes, ma'am.
Which bank?
My lords, it was made through Bank of India, my lords.
Which bank?
Page number 20 is the ledger of.
Which bank? 20.
Yes, my lords, it's the ledger for
That is the
payment.
Ubuntu. That is out of jurisdiction. Where is your bank account? You are for the plaintiff
Yes, my lords.
within jurisdiction.
Yes, my lords.
So where you receive the payment? In which bank you receive the payment? How you are telling that the payment was received within, madam? Gotcha. Bank of India, Kolkata Mid Corporation.
Yes, my lords.
Okay.
My lords, mediation has been taking place. Non-starter report is at page number 35.
35.
Yes, my lords. Annexure I.
So applying for the plaintiff. The plaintiff has filed the present suit, praying for a decree of sum of rupees 23,31,089. Full stop. Counsel for the plaintiff submit that the plaintiff has completed the pre-mediation process, but no starter report has been filed. But the matter was not settled, and accordingly, no starter report was issued on 24th of June 2024. Full stop. Counsel for the plaintiff submit that the plaintiff is within jurisdiction and the defendant is outside jurisdiction, and payments have been made within the jurisdiction of this court. Accordingly, counsel for the plaintiff raised for leave under clause 12 of the latest patent. In view of the submission made by the counsel for the plaintiff, peruse the plaint and the document. Leave under clause 12 of the latest patent is granted. Full stop. Plaint is admitted, subject to scrutiny.
Grateful, your lordships.
Number 12. Item number 12, Your Lordship, I am for the plaintiff.
Yes.
Commercial suit, goods sold and delivered.
Mm.
Plaintiff, Your Lordship, is carrying on business within the jurisdiction. Defendant, Your Lordship, is outside. Your Lordship, the part cause of action has been arising, Your Lordship. The orders were placed, Your Lordship, within jurisdiction. And thereafter, Your Lordship, the security deposit, Your Lordship, check has been given, Your Lordship, within jurisdiction. Payments have been received within jurisdiction. And Your Lordship, then we approach, Your Lordship, the mediation center, and non-starter certificate, Your Lordship, has been given. If Your Lordship kindly takes the non-starter, page 95.
Yes.
Page 95, 13 November 2024, Your Lordship, non-starter certificate has also been given. Playing clause 12, leave, Your Lordship.
Clause 12 only, no?
Yes, Your Lordship. Section 12A, I don't require non-starter has
Already
been
initiated. So from the plaintiff. Plaintiff has filed this suit, praying for the decree for a sum of rupees 42,76,161.11. Full stop. Counsel for the plaintiff submit that the plaintiff is within jurisdiction and the defendant is outside the jurisdiction. Full stop. The cause of action arose within the jurisdiction and payments have been made within checks have been issued. Now, the
payments have been received, Your Lordship.
Payments have been received within the jurisdiction of this court. Accordingly, counsel for the plaintiff prays for leave under clause 12 of the latest patent. At the learned counsel for the plaintiff perused the plaint and the document. This court found that the plaintiff has already completed the pre-mediation process, but it was failed and non-starter report has been issued on 13/11/2024. It is further find that some part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of. Accordingly, leave under clause 12 of the latest patent is granted. Plaint is admitted, subject to scrutiny. Next.
I'm appearing for the plaintiff, my lord. This is my plaint for presentation before my lord seeking leave under clause 12. My lord, in this matter, this is a suit filed in respect of goods sold and delivered for prices not paid. My lord, the plaintiff is situated within jurisdiction in respect of the cause of action which has arisen within jurisdiction. At paragraph 19, my lord, I've already indicated the relevant paragraphs. My lord, the defendant is situated outside. The orders were placed inside, and thereafter supplies were made from within the jurisdiction. My lord,
Supplies were made within the
from within the jurisdiction. It was received outside, my lord. And my lord, with regard to the pre-mediation, my lord, we had already applied before the mediation center. The report is at page 124, my lord. And my lord, on a and all the invoices have also been raised from within jurisdiction. No payment was made, therefore the issue of payment does not arise, my lord. And one more issue, my lord, I had already filed this suit in the regular jurisdiction by mistake after seeking the pre-mediation process, my lord, by an order dated 4th of October, my lord had granted me leave to file this matter.
So and so appearing for the plaintiff. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 72 lakhs 12,913. Counsel for the plaintiff submit that the plaintiff is within jurisdiction and the defendant is outside jurisdiction. The counsel for the plaintiff further submit that the purchase order.
My lord, purchase orders were received within jurisdiction.
Purchase orders have been received within jurisdiction, and the materials have been dispatched or delivered and dispatched from within jurisdiction.
Along with the invoices were also prepared within
jurisdiction, along with all documents. Though the defendant has not paid the amount, accordingly pre-mediation process was initiated. But in spite of the mediation process, the defendant has not come forward for settle the issues. According non-starter report has been filed. Consider the submission made by the counsel for the plaintiff, produce the materials on record. List of clause leave under clause 12 of the latest patent is granted. Plaint is admitted, subject to dispute. Next.
May it please your lordship, no? I'm appearing on behalf of the plaintiff petitioner. This application, my lord, is at our instance because the interim order which your lordship, my lord, was pleased to pass on 30th July 2024, my lord, in a suit for eviction. I am for the plaintiff.
You're for the
plaintiff.
Yes.
My lord, this interim order was got expired on 10th of December. My learned junior, my lord, he was not aware of it, actually not aware of the correct procedure. He thought that like in Delhi or the lower courts, date to date, it will get automatically extended. But that is not the procedure. We have to take steps. And your lordship keeps on sitting even after 4:30 for extending the interim orders. This, my lord, however, was missed. We came up with
That's why I asked to file the...
Yes. Your lordship asked us to file a formal application, my lord. And I am, my lord, most humbly beseeching if this...
Now you're not moving.
Extended.
No confidence.
No. That's. But I want to mention one more thing. But this GA1 is based. It's the defendant is in possession. I am not doubting that. This is, my lord, in connection with GA1. In the affidavit in opposition to the injunction application, they say they don't have any intention to dispossess, to create third-party interest. If my learned friend, if my learned friend, my lord, agrees, GA1 can be disposed through GA4.
May I?
No, I'm saying status quo order can also be passed because I also don't have any intention to oust my learned friend's client by force. This can be recorded. He doesn't have any intention to create third-party interest.
You are the landlord.
I'm the landlord.
He is a tenant.
He is tenant. He is in absolute possession of the entire property. I have no intention to oust him by force. I am before your lordship seeking an order for eviction. He himself says that he doesn't have any intention to create third-party interest in the property. That is his case in his affidavit in opposition to my injunction application. My lord, I am agreeable if there is an order of status quo. He is already enjoying an order of status quo by a city civil court proceedings. So this can be done. GA1 can be disposed through GA4 itself. And the main suit can be proceeded. That's what I was humbly beseeching.
My learned friend has made submissions on my behalf also. Because already I'm enjoying an order of status quo, which is a prior suit, my lord. So GA1 can be disposed of. There will be an order of status quo, and I've got no objections in it.
With regard to nature, position, character.
Yes, my lord.
Everything, my lord.
Your lordship-
GA1 is there.
My lord, no, your lordship, my lord, I have annexed the order of ad interim order, my lord. Your lordship, my lord, can have a reference.
Yes, it is there.
Yes, if your lordship, my lord, sees the entire my lord, narration of the matter is there in your lordship's order. You want to?
So I am disposing of.
Yes, your lord.
Both applications.
GA1
Both
can be
applications,
treated in the
GA1 and
days
GA2,
list. And
GA4 can be disposed of.
So suffering for the plaintiff, so suffering for the defendant. Full stop. The plaintiff has filed the present application in GA Com 4 of 2024. He is praying for extension / reimposition of the interim order passed by this court, originally passed by this court on 30th July 2024, which was subsequently extended from time to time, and lastly till 10th of December 2024. Counsel for the plaintiff submitted due to inadvertence on 10th December 2024, the learned counsel for the plaintiff could not make any submission for extension of the interim order. Accordingly, the interim order was not extended. Thus, the plaintiff has filed the present application for extension / reimposition of the interim order. Full stop. During the hearing of the present application, it was informed by the learned counsel for both the it was informed by the learned counsel for the plaintiff that the defendant had already initiated a suit before the learned civil court at Kolkata against the defendant, and in the said suit, the defendant has obtained an order of injunction, wherein the learned court has
Status quo.
Wherein the learned court has passed an order directing the parties to maintain status quo. Accordingly, on the basis of the said statement, full stop. Now the learned counsel for the plaintiff submit that as the defendant has already obtained an order from the learned city civil court with regard to the status quo of the nature, character, and possession of the property in question, thus this applicant, thus GA1 of 2020, GA1 within bracket com of 2024, wherein the plaintiff has filed and wherein the plaintiff has prayed for an interim order, the same can be disposed of by directing the parties to maintain status quo with regard to the nature, character, and possession of the property till the disposal of the case, so that the suit can be proceeded further. Learned counsel for the defendant submits that, agrees that the defendant has obtained an order of status quo from the learned city civil court, and he has no intention to create any third party interest over the suit property, and submit that if this court will dispose of GA1 Com 2024 by directing the parties to maintain status quo with regard to nature, character, and possession of the suit property, the defendant will not be prejudiced. Considering the submission made by the counsel for the respective parties, GA1, though GA Com 1 of 2024 is not in the days list, accordingly, with the consent of both the parties, GA1 Com 2024 has been taken in the days list and disposed of with the consent of both the parties by directing the parties to maintain status quo with regard to nature, character, and possession of the suit property till the disposal of the suit. That's all.
Yes, my lord.
That's all, my
Your
lord.
lordship can give formal directions on the parties for discovery and inspection of documents.
It's already been given on the last occasion.
Oh, my lord, that is already. I'm very
already
sorry,
given,
my lord.
lord.
It's already there in the mains.
GA, in view of the above, GA Com 1 of 2024 as well as GA Com 4 of 2024 is disposed.
Deep, lord. Deep.
Thank you. Next.
Your Lordship, this is an application which has been filed for amendment of one arithmetical error, Your Lordship.
Amendment
Yes, Your Lordship.
of the plaint.
Plaint.
Yes.
Your Lordship, kindly come to page 4 of the amendment application, Your Lordship. The page 4 wherein the total calculation was stated
32 lakh 43.
43. It should be
003.
003. Your
This
Lordship.
is only.
This is all. Nothing else, Your Lordship.
Where concise statement.
Yes, concise statement, Your Lordship. I have, Your Lordship, kindly come to the master summon.
Concise statement, then page number.
Page 9, paragraph number 19, 20, and 23, and concise statement. And in the prayer portion, prayer A, Your Lordship.
These are the only.
These are all, Your Lordship. Along with the re-verification and all. And Your Lordship, I humbly pray for the leave under leave as per the prayer G, Your Lordship, as well.
What is the G?
G is the lodging of writ of summons, Your Lordship.
After correction.
Yes, scrutiny completed. During the scrutiny, this has been.
Sense offering for the plaintiff. So plaintiff has filed the present application being GA Com 1 of 2024. Praying for amendment in the plaint with regard to the total sum as 32, 43, 003.56 instead of 32, 42, 999.56. Had the learned counsel for the plaintiff perused the proposed amendment, this court find that the amendment as sought for by the plaintiff is formal in nature and will not change the nature and character of the suit. Accordingly, prayer A to G of the master summon is allowed. GA Com 1 of 2024 disposed of. Deeply obliged. Next.
My suit, my lord, in respect of certain admitted claims in on account of 80 lakhs, which was checks were paid to us and dishonored. My lord, thereafter I had filed an application for injunction and attachment. My lord had granted an injunction as far back as in April 2024, and my lord, the interim order period was extended from time to time. My lord, on 22nd of November 2024, the second set of advocate for the defendant had appeared and sought time on the ground of the illness of the defendant's father and his treatment.
Correct.
And the matter was made returnable today, my lord. So nothing, no affidavit has been filed, no letter or intimation has been served. Neither any information with regard to the other bank accounts have been furnished. In the meantime, I should also indicate to my lord, I have been able to obtain a certified copy of the property, which I had already mentioned in paragraph 20 of my application regarding the property which is in his control. My lord, may leave be granted to file a supplementary affidavit to bring on record this document in order to seek an order for attachment over the particular property.
Commercial suit?
Yes, my lord. Well, I have obtained the document on 19th of November 2024. Application, my lord. I will take out an application in that case. My lord,
So what is the prayer for now?
my lord, the interim order is required to be extended and or confirmed, my lord, insofar as the injunction is concerned, my lord. My lord, it is to expire on 24th of December.
Supreme for the plaintiff. None appears on behalf of the defendant. Full stop. By an order, full stop. The matter was taken up for hearing on 22nd of November 2024, wherein the learned counsel for the defendant prays for 2 weeks' time to comply with the order passed by this court for depositing the amount and depositing the amount. Full stop. On the ground, full stop. Full stop. When the matter is taken up today, none appears on behalf of the defendant. No accommodation is sought. Counsel for the plaintiff submit that in the meantime the plaintiff has obtained certified copy of
a property which has been indicated in paragraph 20 of the 24
copy of the details of the property as indicated in paragraph
24A, my lord.
As indicated in paragraph 24A of the present
my lord, page 10. Page 10.
24.
24A. No, my lord, page 10, paragraph 24A.
He will see. present application and press for leave to file supplementary affidavit by disclosing the said document. Counsel for the plaintiff further submit that the interim order which was granted earlier is going to be expired on 24th of December 2024 and prayed for extension of interim. At the learned counsel for the plaintiff, full stop. The plaintiff is granted leave to file the document by way of supplementary affidavit within a week after the winter vacation. Full stop. After serving the copy to the learned counsel for the defendant. This full stop. The interim order granted earlier, which is going to be expired on 24th of December 2024, is extended till 24th of January 2025 or until further order, whichever is earlier. Leaves the matter on 21st of January 2025.
My lord, would it be my lord's pleasure to extend it till 27th of January instead of 24th? 27th will be a Monday, my lord. In case, my lord, it expires, I can come on that day and
extended till 27th. List on 21st.
Wait, please, Your Lordship. This is our suit for recovery of money that is secured under a letter of credit. Lordship will find Lordship's last order dated 22nd November 2024. We had sought time to file a supplementary affidavit bringing on record other banks' accounts of the defendants, which we wanted to attach to the injunction application. Lordship, the supplementary affidavit is ready, but due to the unavailability of the petitioner and some problem at the Advocate and Records Office, we have not been able to file it. We are seeking time to extend time to file supplementary affidavit. I also must indicate, Your Lordship, that the interim order was expiring yesterday. We had mentioned the matter yesterday, and Your Lordship was pleased to extend the interim order as well.
Already extended?
Already extended. 14 January. Yes, 14 January 2024.
Sense offering for the plaintiff, none appears on behalf of the defendant. Full stop. Counsel for the plaintiff submit that as per the leave granted by this court by an order dated 22nd November 2024, the plaintiff has prepared the supplementary affidavit, but due to some unavoidable circumstances, the same could not be affirmed. Accordingly, prays for time. It is further submitted that the interim order is already extended by this court till 14th of January 2025. Let the matter appear on 14th of January 2025. Yes, next.
Gratefully.
My lord, on behalf of defendant number 1, my lord, I'm praying for some more time to file affidavit in opposition. But he is not coming to court because of his father's sad demise.
Who is for the plaintiff?
I'm for the plaintiff, my lord. My lord, there are two GAs.
My lord, I appear for the defendant number 3.
Defendant number 3 has only served us with a copy of a affidavit in opposition through email. That also hard copy also. That my lord, page number 15 and 16 is missing. Whatever they have served upon us. So my lord, kindly.
My lord, I'm filing my affidavit of service and
page 15,
I'll again serve to the defendant number
till the time they don't.
For the defendant number 3.
Yes, I am.
What about defendant number 1?
My lord, I am for defendant number 1. My lord, I'm praying for some more time to file affidavit in opposition because my lord, the advocate appearing for defendant number 1 is not coming to court because of his father's sad demise.
Yes. And what about you, Mr.
Defendant number 2, my lord, I am merely a platform. That is also the plain case. I am a platform wherein the infringing, my lord, copyright which my learned friends claim, my lord, that song was published. I have thereafter taken it down. This relates to a song over which, my lord, the plaintiff claims copyright, my lord, right. My lord, that song from my platform, the infringing material, my lord, has been taken down.
Yeah,
To
this
that
is
effect, my lord, yes, to that
This is the
effect,
IP
I can file an
matter.
Yes, my lord.
It's an IP matter.
It has to be transferred.
Yes, my lord, kindly then extends the interim order.
Extending and
Yes.
transferring them.
My lord, will kindly
And my lord,
report
GA2.
my submission that we have taken down all infringing material as per the plaint case.
My lord, let them file affidavit of compliance then.
But I'm filing my affidavit of service.
What? Affidavit service of?
Of my opposition, affidavit in opposition.
That my lord, 2 pages were missing.
I
What
will
they have
serve
served. Let them
Sense offering for the plaintiff, sense offering for the defendant number 1, sense offering for the defendant number 2, and sense offering for the defendant number 3. Police counsel for the defendant number counsel for the plaintiff submitted. He has received the written statement,
Affidavit in opposition.
Affidavit in opposition from the defendant number 3. But after going through the same, it was found that the page number
15 and 16.
15 and 16 are missing, and prayed for a direction upon the defendant number 3 to supply page number 15 and 16 of the affidavit in opposition. Full stop. Counsel for the defendant number 1 prays for extension of time to file affidavit in opposition. Full stop. Counsel for the defendant number 2 submit that the defendant number 2 is only a platform, and as per the and the defendant number 2 has already removed.
Well, we've already
Removed what?
the orders, the infringing material that's a copyrighted
Removed
song.
the infringing materials from their
Platform.
platform. Full stop.
We'll still disclose the documents in our affidavit.
Platform. Considering the submission made by the counsel for the respective parties, the defendant number 3 is directed to stop the copy of page number 15 and 16 of the affidavit in opposition to the learned counsel for the plaintiff, within a week from date. Full stop. The defendant number 3 is directed to file affidavit in opposition within a week after winter vacation. Full stop. The defendant number 2 is directed to file affidavit stating that they have removed the infringing materials from their platform within a week from the winter vacation.
You can also term my affidavit as an opposition. There are other allegations.
Affidavit. Affidavit in opposition within a week after winter vacation, disclosing that they have removed the infringing material from their platform.
And
infringing material of the from the platform.
My lord, as far as
Counsel for the plaintiffs,
GA2 is concerned,
counsel for the plaintiff submit the interim order which was granted earlier is going to be expired on tomorrow and paid for extension of the interim order. In view of the submission made by the counsel for the respective parties, in view of the considering the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 21st of January 2025 or until further order whichever is earlier. Release the matter on 17th of January 2025.
and as far as GA2 is concerned, that is my formal application for amendment of plaint. I'm just seeking amendment in the cost title, 2 places and just 1 paragraph.
Please to also transfer it to the IP division.
Full stop. This court find that the matter is connected with the intellectual property matter, and thus the matter is released from the list of this court and directed the department to assign the number of IP suit and to place before the appropriate court having determination.
Very well, Lordship. My lord, as far as GA2 is concerned, may I file the affidavit of service, my lord?
Affidavit of service filed by the plaintiff with respect of the GA2 be kept with the record. Yes. Next.
Grateful, Lordship.
Item number 19 is my suit.
Yes.
But here, the application is for judgment on admission, but I'll not move it today. It's just before the vacation. I'll not move it today. Lordship has granted time to the defendant to file affidavit. Nothing has come forward. Insofar as the suit is concerned, Lordship will kindly have a look at your Lordship's last order, 13th December, where Lordship, I had handed over the service report, which would reveal that the defendant has not filed the written statement as yet. The time has expired. Now, Lordship will kindly make this suit as an undefended suit.
So appearing for the plaintiff, none appears on behalf of the defendant. It is found from the service report that the writ of summons was served upon the defendant on 16th of August 2024. But in spite of receipt of the writ of summons, the defendant has not entered appearance either in person or through the advocate. No written statement is filed. Full stop. Time to file written statement is already completed. Accordingly, CS.Com 772 of 2024 be placed in the list of undefended suit. undefended suit, full stop. The plaintiff is directed to file the judge's brief of document within 2 weeks, 1 week.
2 weeks.
Within 2 weeks after winter vacation, full stop. The plaintiff is also directed to file affidavit of evidence of the plaintiff witness within a week thereafter. Full stop. Please give the date of witness. You give evidence witness.
I think how many witness? But there will be one witness.
The witness.
He's from Kolkata. Lordship, any day, Lordship may fix.
February 13. 13 February at 2 p.m. for witness action of the plaintiff.
Grateful, my lord. Lord, perhaps one of the suit number has gone wrong. It's 722.
722.
CSCOM 722.
CSCOM 722.
Grateful, my lord.
Next.
My lord, in item number 20, my lord, I was praying for some time, Lordship. A point of law has been raised by Lordship on an earlier occasion as to whether, in view of the provisions of Order 11, whether an amendment can be sought to a plain wherein new documents are sought to be disclosed. Well, I require some time, my lord. Some time, my lord. Kindly gives me.
No, amendment can be sought.
My lord, but I am
By way of the amendment, can you disclose?
Yes, ma'am. Kindly
without
grants.
the leave.
Yes, ma'am. Kindly
That is
grants. Yes, ma'am. Kindly grants me some
You are
time.
for the plaintiff.
I'm for the plaintiff. My lord, defendant has not.
As per the prayer made
2
by
weeks time after vacation. My lord,
As
let us.
As per the prayer made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 28th January 2024.
I move for the respondent, my lord.
My
Respondent
application, my lord.
defendant.
Lordship, in hearing this matter, my lord, may I file my affidavit in reply?
Of GA?
GA2, my lord. This is the injunction application.
My lord.
Injunction?
Yes, my lord. Lordship will perhaps remember, my lord, this is a borrower's suit against a bank. Lordship remembers there was, my lord, OTS, then the OTS is purportedly cancelled. I am here, my lord, challenging the cancellation of the OTS before your lordship. Brief recap, my lord. There were credit facilities availed of from the defendant bank, my lord, to the tune of about 29 crores. My lord, there was an OTS sanctioned for 12 crores. In terms of the OTS, my lord, joint petition was made by the parties before the Debt Recovery Tribunal because, my lord, the bank had instituted proceedings under Section 19 of the Recovery of Debts Due to Banks and Financial Institutions Act. That's the recovery proceeding. In that joint petition is made, my lord, the OTS is brought on record. On the basis of the OTS, my lord, a recovery certificate is issued for a sum of 12 crores. That is what is provided in the OTS. Thereafter, my lord, the bank purports to recall the OTS on the 22nd of July 2020. My lord,
because you are not paid.
The OTS scheme, my lord, contemplated that within 12 months, I was supposed to liquidate this amount of 12 crores. My lord, the first tranche was supposed to be paid of 4 crores within the first 3 months. I did that. That apart, my lord, there were 2 mortgaged properties lying with the bank as security for the credit facilities that had been availed of. I had, my lord, approached the bank. May I just invite your lordship's kind consideration to those documents directly, my lord?
So what, the bank has cancelled that OTS?
Bank has cancelled the OTS. I am,
and forfeited the amount which you have paid.
Bank
or
is
adjusted.
Yes, yes.
Adjusted.
So my whole case is that, my lord, I had 2 immovable properties mortgaged to the bank. I had a buyer, my lord, during the time frame available for me to make payment under the OTS scheme, my lord. I approached the bank saying, look, I have a buyer in hand who is willing to offer this amount for the properties that are mortgaged to you. And there are valuation certificates obtained, my lord. The offer that I had in hand was in excess of the valuation. So the fair valuation of the land quoted. The bank did not respond at all. Having withheld that permission to sell the land, which was, my lord, made at the appropriate time, my lord, they procured the breach of the OTS. They made it impossible for me to comply with the terms of the OTS. On the basis of that, they, my lord, purport to recall the OTS on the 22nd of July 2020 with the whole malified object of, my lord, claiming the original debt due together with interest, penal interest, etc. On the basis of that, my lord, the bank has now applied to the Debt Recovery Tribunal for modification of the recovery certificate saying OTS has failed. Please allow me to claim the original debt amount together with interest, etc. That has been rejected by the Debt Recovery Tribunal. They have preferred an appeal before the Appellate Tribunal. That is pending consideration. There also, my lord, we have raised the same objection saying that the OTS is not validly recalled. The termination of the OTS is wrongful and invalid. And that, my lord, the amount that the recovery certificate was for, 12 crores, that stands satisfied because after rejecting the permission to me to sell those mortgage properties, my lord, after purporting to recall the OTS in July 2020, the bank goes ahead and sells those properties. in 2023 and 2024 for a consideration much less than what my buyer in hand was offering during the relevant period of time. So that is also, my lord, an act of the bank.
What do you want here?
My lord will kindly see the prayers.
Interim order.
Interim order, my lord, restraining them from alleging that the OTS stands cancelled.
DRT in session of the matter.
My lord, DRT is not in season of this object, and the DRT cannot be. Let me just try to satisfy your lordship on this account. There are 3 decisions I would like to place before your lordship for your kind consideration, my lord. 2 decisions on the proposition. This hand up first, my lord.
Will you ready to pay the amount?
My lord, the OTS amount is completely repaid. I am saying that, my lord, whatever is owed to the bank, that has been repaid. The bank is not allowed to, my lord, allege that the OTS is cancelled and claim anything in excess of that to me. That is my whole case.
What was the total amount in the
12
OTS?
crores. 12
You
crores
paid?
is repaid, yes.
When you paid? Before cancellation, after
4 crores I paid, my lord, before cancellation during the OTS scheme. Thereafter, my lord, the rest has been appropriated by the bank from the sale of the immovable properties.
Sale of the
Yes. So the entire amount is today repaid. The bank says,
what was the condition of the OTS?
OTS said that I have to pay within the stipulated time frame. In the event I fail to pay, then the original debt will revive. That is provided. My lord, my whole case is that under section 55 of the Contract Act, my lord, there are reciprocal obligations. It was the obligation incumbent on the bank to allow me to sell the property. Kindly appreciate, my lord. In an OTS, normally, how is the borrower to repay?
Why you not file the writ application?
I beg your pardon, my
Why
lord?
you not file the writ application?
My lord, I could file the writ application. My lord, no. My lord, disputed question of fact will arise. Only thinking that, my lord, what I can ask for in writ, I can also ask for in suit. The writ court would be hands off saying disputed question of fact. So I thought, my lord, more prudent to approach the suit court. Certainly, I could go by way of writ. But, my lord, perhaps disputed question of fact, your lordship is better equipped to adjudicate. That is the whole thing. Nothing more than that. With respect to adjudication, the jurisdiction, may I try to satisfy your lordship, please, my lord? The first decision I'd like to rely on, my lord, is 2023-1 SCC 1. Yes.
But I think my learned friend is, Lord, I am appearing on behalf of the defendant bank.
Yes.
I think Ms. Rao has already indicated to your lordship that, Lord, we've taken the point of maintainability on the ground that that's
No, she has not opened her mouth.
I'll
Now
indicate, my
she
lord.
has
I can indicate, my lord. My learned friends have taken out
that it's not a commercial suit. My lord, we have a very
What is the time
elementary.
there? You are appearing. What is the time there?
5 o'clock in the morning, I suppose.
No, my lord,
Wake him
it's
up.
6 now. It's 6 now.
Yes.
Senior lawyer,
I can prima facie try to countenance the objection, my lord. My learned senior friend says that this does not constitute or fall within the definition of a commercial dispute under the Commercial Courts Act 21C1, because this is not a dispute arising out of a mercantile document.
What is the objection?
My lord,
If you are maintainability, then you have to argue first.
my lord, no, that we have taken out an application that is returnable on the 23rd.
Yes, not before your lordship today.
It's
But
returnable on
I
the
prima
23rd.
facie, since the objection has been raised, my lord, I will try to address it. If your lordship will
No, my lord, let my application come, my lord. I'll
Yes,
tell
my
you,
lord, let
lordship.
that application come
This-
on the 23rd.
But this will amount to inherent lack of jurisdiction.
Correct.
But if your lordship considers that, my lord, this is before a commercial. We say that this is not a commercial dispute. Now, if this is not a commercial dispute, the question of, my lord, whether the suit is otherwise not maintainable, whether, section 34 would be a bar, whether other issues would be considered, my lord, that will become irrelevant.
May I submit, lord? I am equipped with the Supreme Court's judgment in the matter of Tayabhai.
No, but this is not a question of Supreme Court, or this is not a question of House of Lords, but it's a question of whether it constitutes a commercial dispute or not.
I will take it.
Very well, my lord.
Let her application also
Let
come.
my application come, my lord. So,
My lord, it's only that I was, my lord, really in need of urgent interim relief, which is why. Please, my lord.
Because they have filed an application.
Yes.
Let the application
Copy
come
of
up.
the
Very
server.
very well.
We'll see to that. So she will get an opportunity to argue first with regard to the maintainability. Then you can give the answer of both.
Yes, my lord.
So and so appearing for the plaintiff, so and so appearing for the defendant. Full list of counsel for the defendant submitted. The defendant has filed an application being J2.
J2 is my application.
3. Form of 2024. Praying for rejection of plaint.
Yes, my lord.
Praying for rejection of plaint, and the matter will be listed, and the said application will be listed on 23rd of December 2024. In view of the submission made by the counsel for the defendant, let the CS Com 767 along with GA2 of 2024 and GA3 of 2024 will be restored on 23rd of December 2024.
Great, Lord.
Under the head. Yes, next.
22.
Lordship,
The 22, I appear for the defendant number 2.
I'm appearing for the plaintiff petitioner, Your Lordship. In this case, Your Lordship was pleased to grant an ad interim order, which
Lordship, I appear for the, if I may indicate, I apologize for not being in front of your Lordship physically today. Lordship, we had carried an appeal from Lordship's order, which had been passed attaching our bank accounts to the extent of around 60 lakhs. And the appeal court has, Lordship, passed an order on 25th November 2024. My junior is present in front of your Lordships. If the order can be handed up. So Lordship will see that the appeal court has directed that certain deposit is to be made before the Registrar General of the Honorable High Court within 23rd December. We are in the process of making that deposit. And if the deposit is made, then the proceedings before your Lordship will be stayed and the parties have been referred to mediation thereafter. So Lordship, I am requesting that keeps this matter anytime after the vacation. So that we can make our deposit in the meantime, and thereafter the matter may take its own course.
They're fixing on 23rd, 24th, because by 23rd he has to file on or before. As per the order, without prejudice to the right and contention
Your
of the
Lordship,
party, the
kindly-
appellant shall deposit 25 lakhs in 2 tranches on or before 23rd of December.
Now, Your Lordship kindly goes through the 25th November's order, second page, second paragraph. Till such time the cash security is filed in terms of the order, the interim order passed by the learned single judge shall continue. So, Your Lordship kindly extends it.
That's why I am fixing on 24th. Let you come on 23rd, stating that you have filed.
Now,
Otherwise,
Your Lordship,
I have to continue the stay.
yes, Your Lordship, but probably I am extremely sorry. My learned advocate on record is on legs before court 16. Perhaps it is expiring today, which is why Your Lordship has kept it today. So if it expires, then my order is gone, which they are which is why they preferred an appeal before the honorable division bench. So what I'm only seeking is this: if the interim order is expiring today, Your Lordship kindly extends it. And
Why I am extending it in 24th.
Oh,
Let the
grateful.
matter come on 24th. If they will deposit 23rd December, then no necessity
Grateful.
of
I apologize.
further order. If they are not deposited, then I will extend the time.
Grateful, Your Lordship.
I will extend the interim because they are not deposited the amount.
Grateful.
Yes.
Much obliged. Much obliged.
No, only one thing, my lord. My lord, I appear for the defendant number 2. My lord, pleadings have been filed before your lordship as well as before the division bench. But I was only requesting if copies of pleadings can be given to me.
Of which?
My lord, of the application that has been filed before your lordship.
You are appearing for?
Defendant number 2.
He's my learned friend. Is
Serve the copy.
Yes, very well. We have already done so, but we'll serve it again.
Already till such time. Sense appearing for the plaintiff, sense of the defendant, sense appearing for the defendant number 2. Defendant number 1 submit that being agreed with the order passed by this court dated
5th of November's order, Your Lord.
Number 2025 and 2024, the defendant number 1 has preferred an appeal before the appellate court being APOT number 369 of 2024, wherein the Honorable Appellate Court has directed that without prejudice to the rights and contention of the parties, the appellant shall deposit rupees 25 lakhs in cash in 2 tranches on or before 23rd of December 2024 with the learned registrar of this court. Police of the Honorable Division Bench, Honorable Appellate Court have further directed that till such time the cash security is filed in terms of the order, the interim order passed by this court shall continue. Police stop. Counsel for the plaintiff submitted the interim order passed by this court dated 25th of November 2024 is going to be expired today, tomorrow.
Till 22nd, your lordship, it is
23rd is going to be expired on 23rd of December 2024. In view of the matter, let the matter appear on 23rd of December 2024.
Lordship, much obliged. Just a point of clarification, Lordship. Perhaps in the first line mentioned that your Lordship's order is dated 25th November. The division bench's order is dated 25th November. I carried the appeal from the injunction order, Lordship.
My order is 22nd November.
Lordship.
22nd November, no? And order passed by the Honorable Division Bench dated 25th of November.
Much obliged, Lordship.
My lord, I am appearing for the defendant, my lord, in this matter. My lord, parties had entered into an MOU on, my lord, 22nd of November 2024. In terms of the said MOU, my lord, my friend was to withdraw the suit. Now, my lord, he had sent a WhatsApp message containing a new terms of settlement incorporating other terms. And yesterday he had sent a mail
Lordship,
saying,
these are the
kindly
two
see the
mails,
contents of
Lordship.
the mail.
These are the
Kindly
two
see.
mails, Lordship, I have sent
If
it.
the parties want to have different terms of settlement, they have to sit together and discuss.
No, Lordship.
Yes.
She has not opened the terms of settlement what I have sent. I have annexed the entire document which is they have signed it, Lordship.
Let the parties discuss.
So there is no new terms, Lordship.
It is whether it is new.
No new
My
terms.
instructions
I have
are that the
annexed
terms are
I have sent the format of a terms of settlement, and I have
and kindly see
stated.
the email which has given. I am writing in this email that I've already sent you the final draft. Yes, I'm reading it. The final draft of the terms of settlement. Please take print and get it signed with by your client so that the same can be filed tomorrow. This is not the way it is to be done.
Lordship,
Both
I
the
have
parties
sent
are required to sign it. Not my client alone. I'll take a print out. This is not the way.
Lordship will see the
Kindly
first mail. On 2nd of December, it was sent, Lordship.
My instructions are, my lord, with I'm having a copy
On
of
2nd
MOU.
December, first
Yes,
mail was
received
sent. Now, yesterday I have sent it as a reminder, Lordship, it is.
So what do you want?
If they
My
don't,
lord, may I just submit, my lord?
Matter is settled or
Matter,
not?
my lord, so far as we are concerned, my lord, we have made the full payment in terms of the MOU.
Correct.
And my lord, and then he has to withdraw the suit. Now he wants certain other terms, my lord. The complaint, yes.
Lordship, no other terms.
Where is the terms?
Terms, my lord, this is the MOU.
This is the original copy, Lordship.
Whatever the MOU is, my lord, kindly keep the matter after vacation. And if the parties agree to different terms, then my lord, they will sit across and settle it. Because they want the complaint.
Actually, what I have sent it, Lordship. No new terms, nothing.
I have a copy of it. You have sent me on the WhatsApp.
Doesn't contain any term.
You have sent me a WhatsApp, Mr. Upadhyay. I have gone through it. Don't say I have not seen it.
This is the email I have sent.
I'm not talking about the email. You have not sent. I have got the terms of settlement which you have sent me on message.
That is in addition to this I have sent you.
Yes, it contains the clauses which are not in the MOU. Yes.
What content?
In view of the aforesaid terms of settlement, all the cases, including the complaints filed before the police station by the parties, be treated to be withdrawn and necessary steps be taken by the parties to intimate the authorities of such a settlement. You know, these are the terms which parties have to agree. I'm not aware what complaints have been made with the police and what are to be withdrawn. It is not there. It's totally different from the MOU. Let the parties sit together during vacation. If they agree, my lord, I don't have any objection. It can be
What
filed.
about this agreement entered between you?
This is I am abiding by it. I have paid the money, my lord, in terms of this MOU.
Yes. So what
So,
happened?
my lord, they have
has to be
remained.
filed, Lordship,
No,
by way of
they
another.
have to withdraw the suit, my lord, in terms of
Okay,
this.
I am fixing a date after vacation. Come with the application.
Very well.
Come with the total.
Yes.
Either you
Terms of settlement, it will be a part and
come with the
parcel.
terms of settlement along with the notarized or whatever it may
In
be.
terms of the MOU.
Yes.
It has to be in terms of the MOU.
So-and-so appearing for the plaintiff. So-and-so appearing for the defendant. Counsel for the artist submit that though the parties have entered into terms of settlement, but it has not been finalized and prays for time to file the proper terms of settlement executed between the parties before the notary public or before the oath commissioner. Accordingly, the case is adjourned. Let the matter appear on 21st of January 2025 for filing Memorandum of settlement between the parties.
Deeply.
This is my application, my lord, under order 13A, my lord, for summary judgment, my lord. In this matter, my lord, the goods sold and supplied, my lord. I am a jeweler, my lord, and defendant is Senco Jewelers Private Limited. Earlier, my lord, 2 degrees has been passed by your lordship in the 4 checks were issued. My lord, 3 memos were issued.
Have you issued the notice?
Yes, my lord. Affidavit as service has
What
been
about the
filed.
suit?
Suit, my lord, returns, deed of summons has been served, my lord. No retention has been filed. And in this application also, affidavit of service has been filed.
When the suit is fixed?
Well, I'm taking application for summary judgment, my lord.
Correct, but I have to see the suit also, summary judgment, whether writ of summons is served or not.
Yes, my lord. It kindly comes to page, my lord, 49, my lord.
49.
I have obtained a certificate from the deputy registrar, my lord. It has been served on 10th of September 2024.
Basak, accountant of the defendant company for the defendant. 10th of September.
10th of September.
Correct. Then
both are within jurisdiction, my lord. Only 3 memos were, my lord.
Where is the report? They have not entered appearance. Where is the report? They have not entered appearance or not filed return statement. You have to obtain reports, sir.
My lord.
You obtain report, come on the next. I am fixing the suit along with this application too.
My lord.
Along with after vacation.
My lord.
In the meantime, you obtain the report. Then I will dispose of it. They will not appear.
Yes.
What will happen? Constitutions appearing for the plaintiff. The plaintiff has filed the present application under chapter 13. Chapter 13 or order 13?
Order 13A of CPC, my lord.
Order 13A of the Code of Civil Procedure, 1908. For summary judgment. The counsel for the plaintiff has relied upon the service report dated 19th September 2024, wherein it reveals that the writ of summons was duly served upon the defendant on 10th of September 2024. But the plaintiff has not disclosed any document whether the defendant entered appearance or the defendant has filed return statement. Accordingly, counsel for the plaintiff waits for time to obtain report from the concerned department to show whether the defendant entered appearance or filed return statement. In view of the above, let the matter appear on 17th of January 2025 along with CS Comp 762 of 2024 under the same heading.
I'm good.
My application, Millard, I had completed my submission. This is Millard regarding Millard recalling of an order where Millard, my junior, was had accepted the plaint, and I had Millard, tried to show that there was no writ of summons served, no attempt made to serve writ of summons, and that does not as an estoppel.
Yes.
Yes, madam. Millard, in this matter, Millard, we have filed a suit, Millard, wherein Millard, already Millard, summons were lodged. Now, Millard, after that amendment was allowed. Now, Millard, Lordship will kindly takes, Millard, my first point in respect to the maintainability point, Millard, which I have taken at the first instance, Millard. Lordship will kindly takes, Millard, the defendant herein has prayed for a Millard recalling of your Lordship's order, Millard, which was passed on 17th August 2023.
Where is that?
Yes. Now, Lordship will kindly takes, Millard.
17th August.
Yes, my lord.
Counsel for the defendant accepted the notice of the amended plaint and the filing of written summons upon the defendant is dispensed with. Yes.
My lord, the plaintiff has carried out the amendment in the name of the defendant, and after amendment,
The amended plaint has also been served upon the counsel for the defendant. As the counsel for the defendant has accepted the notice of the amended plaint, hence for filing fresh writ of summons on the defendant is dispensed with. Mala counsel for the plaintiff submits that the plaintiff has also filed an application under GA 120 praying for in interim order. Now, my lord, application the name of the defendant appearing for Crest Logistics, my lord, and the plaintiff has amended the name of the defendant. Accordingly, the plaintiff has filed a supplementary affidavit in connection to GA 1-2020 for treating the name of the defendant as CLE Private Limited instead of Crest Logistics and Engineers Private Limited. Now, a copy of the supplementary affidavit is served. The counsel for the defendant prays for time to file the written statement in the suit. Let the written statement be filed within 30 days. So, my lord, Lordship, my lord, kindly sees, my lord, this is the August 17, 2023 order. There was a specific direction, my lord, the dispensation of service of summons. The learned lawyer has accepted the service. Now, my lord, I'll just take your lordship, what has happened in this suit. They appeared, lordship will kindly takes the notes of the dates, my lord. Their first knowledge is from 7th September 2022. And that is evident at page 68 of their application. Lordship will kindly takes, and I'll also corroborate with the statement.
68?
Yes, madam. Annexure C, my lord. Now, Lordship will kindly seize Dascom Commercial, now Crest Logistics Engineers Private Limited, Raheja Point, Nehru, so and so. After that, also at Shakespeare Court, flat number 5C21A, Shakespeare Sharoni, Kolkata 17. I have filed a suit.
This is a mediation.
Yes. What I am trying to show before your law.
Mediation.
Yes, mediation. Now, what I am trying to show, my lord, is a knowledge. Now, my lord, Lordship will kindly see, my lord, so the office address was still their knowledge from 7th September 2022.
Yes.
My lord, when this plaint was admitted, my lord, we have also prayed for a, my lord, clause 12 leave of the, my lord, latest patent act, my lord, so because of the part cause of action is also there. I'll come to that, my lord. Now, Lordship will kindly
What
take
you want to say from the page 68?
Page 68, my lord, the knowledge.
Because mediation.
My lord, what I'm trying to show is before Lordship, my lord, they have made specific amendments. I'll show you, Lordship, that, my lord, for the first time, when the plaint was served in the open court to the learned lawyer of the defendant, it was very short period of time, so they could not go through the cause title, and, my lord, amendment was allowed uncontested with the consent of the defendant. So, my lord, the learned lawyer who was appearing for the, my lord, defendant, my lord, she could not, or he could not, my lord, get the time to at least read the cause title. So, my lord, I am just showing from the first document, my lord, they have placed is the Annexure C, which shows that, my lord, from 7th September 2022, the knowledge was within the in favor of the defendant is that, my lord, that there is an existence of office at Shakespeare Sharoni, Kolkata. My case was also, my lord, plaint was admitted under clause 12, my lord, seeking a leave of clause 12. It's not that, my lord, I have also played, yes. I'll show that, Lordship. Now, Lordship will kindly takes, my lord, page 70.
70. 70.
Yes, my lord, page 70, my lord, Annexure D.
Yes.
Now, my lord, only I am just showing a line, my lord. When this plaint was admitted, my lord, leave under clause 12 of the latest patent 1865 was granted. So, my lord, my case is that, my lord, cause of action is a part cause of action, my lord, arose in respect to the Shakespeare Sharoni, and also, my lord, in respect to the other areas of concern. Now, Lordship will kindly takes, my lord. Yes. Now, my lord, after that, my lord, Lordship will kindly directly takes to, my lord, Annexure F, page 72. Yes, this is very important. Why I am showing before your Lordship, Lordship will kindly seize the cause title. It's Shakespeare Court is given. No, there is no dispute. Now, Lordship will kindly takes the date of appearance is on 30th March 2023.
Where from?
The page 73, my lord. Yes. Now, my lord, it was accepted. Now, my lord, 30th March 2023. Why I am showing, my lord? Because, my lord, after this filing of Vakalatnama, they have received the plaint. Lordship will kindly seize at at page 85. This is after the amendment, my lord. When we served, Lordship will kindly seize.
So defendant has filed the wakalatnama.
Yes. So, my lord, date is very important. Why I am saying, my lord, because I will corroborate with the rules of
30th
the.
March
Yes, 30th March
2023.
2023.
Correct.
Now, my lord, Lordship will kindly seize the summons of an amended plaint. Because my lord, when my lord, the amendment has come into my lord, existence, my lord, then my lord, fresh summons has to be served. Now, my lord, they have received the summons.
No, after the 30th March 2023.
Yes, my lord.
Whether the matter matter appeared.
Yes. Where is
yes.
that? Well, I'll show the orders, my lord. Lordship will kindly seize, my lord. Accept. Yes. No, yes. 2023. Yes. March 2023.
29 March.
Yes. Well, 29th March 2023.
Order dated page.
Well, page 101.
This is prior to the wakalatnama.
Yes. Well, page 100. Well, Lordship will kindly take, my lord.
Yes. 13th March.
Yes. But counsel for the plaintiff submits that the plaintiff will take appropriate steps. Sorry, my lord. Counsel for the defendant submits that the suit was filed in the year 2020, but the name of the defendant has changed in the year 2019. So, my lord, only the name. My lord, they have, my lord, pointed out that, my lord, the name is required to be changed because there was certain, my lord, name change history because 7 to 8 times my name has been changed. Now, my lord, Lordship will kindly take, my lord, counsel for the plaintiff. Yes. The counsel for the plaintiff submits that plaintiff will take appropriate steps for change of the name of the defendant and prays for 2 weeks' time. In view of the submissions made by the counsel for the respective parties, let the matter appear on 29th March 2023. In the meantime, the plaintiff is at liberty to appropriate steps. Now, Malad, thus.
So, on that day, 13th March, when the defendant has informed this court regarding change of name, on that day, the name was Crestologist.
Crestologist. After that, CLE has been transferred.
Then 13 March, the matter was appeared on 29th March.
29th March. Now, 29th March,
You have not carried out the order.
Yes. Now, counsel
You
for.
prayed for time.
Yes. But the counsel for the plaintiff.
But 30th, they have filed the wakalatnama on the name of the
Yes.
new.
Now, the most important thing is, my lord, 18th May 2023 order. That is at page 102. Why 102? So date is 18th May 2023. So the landed lawyer has received the Fokalatnama. He has filed the Fokalatnama in the department. Now Lordship will kindly seize, my lord. The plaintiff has filed the application being GA number 2, praying for amendment of the name of the defendant in the cause title and some other pages as reflected in the proposed amendment. Counsel for the defendant submits that the amendment as sought for by the plaintiff is formal in nature. No objection has been given. In view of the submissions made by the counsel for the respective parties, prior A to E of the master summons are allowed. Counsel for the plaintiff submits that the plaintiff has filed an application for EN. Now, my lord, so my lord, 30th March, my lord, from that day, if I take, my lord, from that day. So, my lord, Vokalatnama has been filed in the department and he has, my lord, knowledge, and he has also not opposed in respect to the amendment. And there is also no dispute in respect to the address. Now, Lordship will kindly take 17th August 2023 order.
Yes.
That is at page 105.
Yes.
Well, counsel for the plaintiff submits that in terms of the order passed by this court, the plaintiff has carried out the amendment in the name of the defendant, and after amendment, the amendment plaint has also been served upon the counsel for the defendant. As the counsel for the defendant has accepted the notice of the amended plaint, hence for filing fresh writ of summons upon the defendant is dispensed with, and Mala so and so. So this is the order under challenge. Now, Mala Lordship will kindly seize it is a submission on behalf of the defendant that the plaint has been served. Now, Lordship will kindly take their paragraph they have made in the application. That Mala I'll be showing. Mala page 5, paragraph 11. The suit appeared in the list of the Honorable Justice Krishna Rao on August 17, 2023. The plaintiff advocate handed over a copy of the amended plaint to the advocate of the defendant. The advocate of the defendant, not having the opportunity to scrutinize the amended cause title of the plaint. Now, this is very important. Why, Amanda? Or to take instructions from the defendant, accepted the copy of the amended plaint during the said hearing. In such circumstances, this Honorable Court recorded that notice of the amended plaint has been accepted by the defendant and dispensed with filing fresh writ of summons upon the defendant. Now, Lordship will kindly takes this paragraph, the order, and the annexure H.
Yes.
Lordship will kindly takes annexure H, that is at page. That is at page, my lord, just 84, 85. Page 85. 84, my lord, is the Lordship's order on 27th February. After that, my lord, annexure H is a GA number 2. Lordship has got it, my lord?
Yes.
Yes. So, my lord, fresh summons has to be served after the amendment. Now, Lordship sees the, my lord, the endorsement received Mondol 12th April 2023 at 12:05 p.m.
Yeah.
So, my lord, this was page 85. So, my lord, 30th March, they have received the, my lord, in respect to that, my 30th March, they have received they have filed the Vokalatnama. After Vokalatnama filing, they have received this summons. But, my lord, they have specifically, this is the summons. Lordship will kindly see. Yes, my lord, page 87. This is the amended GA number 2.
Summons taken
Yes,
out.
master summons. Now, page 87, Lordship will kindly see the summons taken out by Saptarshi Mal, to Sinha and advocate, Sinha and company advocates, 5 kilo. So, what I am trying to show before your Lordship is that, Lordship will kindly take this point. Their contention in the paragraph 11 is that, my lord, in the open court, the plaint was handed over. So, naturally, we also could not go to the record. That might be a point. But, we are showing from the records that it was, it was served on 12th April, and after, filing of the Vokalatnam on 30th March 2023, which has been also, in the record. So, they were duly, authorized, instructed, whatever may be, so they knew everything.
So this was received on 12th April.
Yes, 12th April.
The order which is impugned, that is 17th August.
Yes. So, they have told that I have been served. I have been served. Vokalatnama filed 30th March. 12th April, we have been served. So, that time they were having the authority to receive. In the open court, they have said that, yes, we have received dispense of some service of summons. But in the application, they are saying.
So your case is that they filed Vakalatnama March. They received the writ of summons on 12th August. 12th April.
12th April.
17th August, only this court has recorded the summons.
Yes.
So that's why the statement made in paragraph
Is
11
totally
is not contrary to the record.
Great.
That is
my point. Now, my lord, now, my lord, on this point, my lord, I'll show, my lord, it is necessary to give, to show before your lordship the rule. My lord, subject to correction by your lordship, my lord, I'm always ready to correct myself, my lord. Now, my lord, I'll first place, my lord, chapter 1, my lord.
Yes.
Chapter 1, my lord, rule 4, sub rule 2.
Rule 4?
My lord, chapter 1, my lord, rule 4, sub rule 2. Now, my lord, any notice, writ, summons, order or other document required to be served on an advocate acting on the original site shall be served at such office address and shall be deemed to have been properly served if served or left at the place on his refusal to accept the service of the same. Now, my lord, 5, rule 5, chapter 1. An advocate shall not be entitled to act in the court unless he has filed the Wakalatnama, and an advocate shall not be entitled to appear and plead before the court unless he has filed Wakalatnama or is instructed by an advocate who has filed the same, provided that the court may, for any special reason, permit any other person to appear before in a particular case. Well, why I am showing these two rules? So, without Wakalatnama, an advocate cannot appear. Well, this nothing to be new to us. Now, once he has received the Wakalatnama and he has filed,
No
on
dispute.
no dispute, and he has, so we have served in the office of the learned advocate on record, and your lordship recorded service has been dispensed to me.
Correct.
So what recalling they are praying for?
Okay. That's all.
No, I'll take my note. Now lordship will kindly take my lord. Chapter 8, I'll show 2 or 3 rules. Lordship will kindly.
You are saying that writ of summons you have served.
After the amendment, after amendment, that is
12th
12th April, yes.
84.
That's the master summons. No, he is reading chapter 5. I was saying read. That's what I was asking.
Yes.
Now, no, along with the plaint and everything. No, I'll clarify because the entire thing has been given with the plaint and documents, everything has been. So,
That's why I asked him twice. What is this?
I was also trying to understand.
No,
because he read
Knowledge of the application, what is
today, I am before your lordship. There is a technical point which has been taken by my learned senior friend. There was not a case that we have not lodged the summons. It is not a case. We have lodged the summons. Now, service was not affected as far as report goes to show. After that, amendment has came to the picture now. After amendment, we have served the plaint, amended plaint, and all the documents. My
17th August.
Yes. No, April. 12th April.
No, 12th April, the master summons.
Yes.
Master
So
summons
after
they
that,
received.
it has been served. After normal.
Summon they have received.
Yes, yes. After that,
summon they have received. In the master summon, that the name is the crest, not the plea.
no.
Kindly come to that.
Yes, yes. I'll show.
was disputed. Yes.
My only contention is that dispute in respect to the address. Address was never disputed. That is my case, man.
Kindly come to the page 84.
Yes,
85.
I'll correct.
The name is the master summon. Crest.
No. Yes, yes. This is a amendment. Page 93, we have stated that the name has been changed. Page 93. Yes. Now, my lord.
Yes. Order 8.
Yes, madam. Order 8, madam. Rule 6, madam.
Chapter 8, Rule 6.
Yes, madam. Chapter 8, Rule 6, madam.
Yes.
Madam, Rule 8, madam. Fresh summons upon further amendment. Where upon the further amendment of any summons to appear and answer, the registrar and master shall be of opinion that a fresh summons shall be prepared, and upon payment of the usual fees, taken out by the sheriff within 14 days. So in this case, my lord, we have served to the direct to the learned advocate record of the yield. Yes. Now, my lordship will kindly takes, my lord. Rule 25, if your lordship takes, my lord.
Service on advocate.
Yes. So, my lord, we have done it. Now, my lordship will kindly takes. Yes. Yes. Now, my lord, the most interesting thing is that, my lord, after they appeared, after the mediation proceeding, they have filed a Section 8 application. 17th August. Now, in Section 8 application, my lord, if your lordship can bring the record, my lord, I don't have any problem, my lord. The first paragraph they have stated on perusal of the plaint, because they have taken a specific pleading in respect to the Section 8 is concerned, that there is an arbitration clause, so they want to fight it. So, after all those contested hearings,
What has happened to the arbitration?
Section 8, they have lost, and even they have tried to, prefer an appeal, but they have not preferred. Now, my lord, my contention is that, my lord, today, only basic thing what I am trying to.
Section 8 application.
Yes.
Have you not enclosed in the
No,
HGA?
it's not my application. Mala, if your lordship can bring the record, Mala, your lordship can. Mala.
If you're taking the plea, you could
Yes.
have been brought on record so that they can give the reply to that.
But that is if your lordship wants, Mala, lordship can call it, Mala, because that is an important document. Because in section 8, first paragraph, they have stated on the perusal of the plaint. So, Mala, this is the paragraph they have stated. So they have never disputed the address. Mala, they are only taking the Shakespeare Sharoni office was never. It's an incorrect fact. So based on incorrect fact, the learned lawyer accepted the service. If it is an incorrect fact, this suit, my lord, this the what I have tried to show before the man in the respect to the service is concerned that is bad. That is what I have kind of followed, my lord. Now, my lord, my case is that, my lord, it's a part cause of action. I have tried, today this Reliance is the main group. In lordship has also held in section 8.
Only the what is only the point here with regard to the address of the defendant.
Yes, only that.
Rightly, wrongly, the defendant counsel has accepted. Subsequently, it is found that though the name of the defendant is there, address is not correct.
Yes.
Correct. So, what is the address of the defendant? Correct address of the defendant.
Correct address is the defendant. We have also stated and carrying on business in the. Lordship will kindly takes my amendment application. Amendment application. Yes. Yes. My lord, lordship will kindly takes, my lord. Yes. In our amended application, my lord. Paragraph 9. Yes, paragraph 9, my lord, and my lord, paragraph, my lord. My lordship will kindly takes page 96.
Yes.
Whether the particulars Crest Logistics and Engineers Private Limited, a company within the meaning of Companies Act 2013 and carrying on business at Shakespeare Court, flat number 5C21A, Shakespeare Sharoni, Kolkata 17, within the aforesaid jurisdiction as appearing in the cost title be deleted, expunged, and the particular CLE Private Limited, a company within the meaning of Companies Act and carrying on business at Shakespeare Court, flat number 5C21A, Shakespeare Sharoni, Kolkata 17, within the aforesaid jurisdiction be added, incorporated, and plaint accordingly. In a paragraph 9, my lord, where we have said, but lordship will kindly takes paragraph 9 once, my lord, page 93. That it would appear that immediately thereafter the defendant has taken expeditious steps to change its name and registers address, and as on December 9, 2019, the name of the defendant stood changed to CLA Private Limited, whereof is registered as Raheja Point, Wing Nehru Shamrao, Vital, Santa Cruz, Mumbai. Now, my lord, it's a registered office in Mumbai, there is no dispute, my lord. But the cause of action has, my lord, arisen in part cause of action here in Raghunathpur, some, my lord. So,
that's correct.
Yes,
but
madam.
kindly come to para 9 and read with para B.
Yes,
17B.
Yes, madam.
So what is the address you wanted to mention in the plaint?
Plaint is 6 years only. Why?
So you will not disclose the registered address when you are having the knowledge of this.
Registered address, my lord, what has happened, my lord? That registered address, my lord, will kindly see, my lord, in my injunction application, my lord. I have also sent to the registered address. Now, what has happened, my lord? I have shown, I have annexed all the ledger and all the bills, which will be quite, my lord, substantive to show that Shakespeare Court was, my lord, the office. We have sent the bills. We have received the bills.
Where is the amended plaint?
Yes, my lord.
Amended plaint is annexed. Page 50.
Page 50 is the, my lord, amended plaint, my lord.
Yes, kindly come, page 55.
Yes, my lord. And carrying on business at, my lord, Shakespeare Court, flat number 2.
Okay.
Yes, my lord.
Why registered address is not mentioned?
But a registered address is not mentioned, my lord.
You have filed the suit.
Yes, my lord. I have filed a suit. Now, my lord, one lordship will kindly see, my lord, at that point of time when the suit was filed, my lord, we have registered bills, my lord, which shows that my office are carrying on business at Shakespeare Court.
That's correct. But if you are having the address of the registered address, that is the plea they have taken.
But registered address also, my lord, 2 times changed. My lord, lordship will kindly see, I'll show you from the documents. If your lordship
change or not change.
But we don't have any idea. Lordship will kindly see.
No idea. 90 page 96, 93,
Yes.
paragraph 9.
This is
93, paragraph 9.
This is after they have given the address.
Correct. In the amendment application, which you want to amend the plaint in the amendment application in paragraph 93, page 93, paragraph 9, you have disclosed the registered address. But at the time of proposed amendment, you have deleted the registered address and come to the 29A. 21A of the sex, but they are denying the 21A sex, whether it is there or not. That's why subsequently when they came to know after receipt of the amendment, when the amendment plaint was served.
On the date is not with me today, but after that April.
Only amended plaint was handed over after amendment. They never even lodged a writ of summons.
No, that's when it was served.
It was served on that.
That is our case. When you served to the advocate who had appeared.
On 17th of August.
On the same day?
On the same day, in court they handed.
No, not in the court. We have not done.
Hey, court order lekha ache.
No, it's served. It has been
amended plaint has been served upon the counsel for the defendant.
Not in the open court, as per my submission.
Correct. Subsequent.
Then closed court.
Subsequent.
No, it was previously. Date today to be very specific on this but today I'm not I don't have that record with me when it has been served. It's a communication letter. Now what has fallen from your lordship is that in respect to the Raheja point Mumbai they are trying to make out but that
is one thing. Second thing, 17th August 2023, this court passed an order accepting the submission of the defendant that she will appear, the writ of summons has been dispensed with. Correct. And this court has directed to serve the writ of serve the amended plaint to the counsel for the defendant.
Yes,
so when you have, and admittedly you have not mentioned the registered address of the defendant's company in the cost title.
Which address I'll mention? Lordship will kindly take the history.
Complete, then you give the answer. You have not mentioned the registered address and you mentioned the 21A expert serenity. Correct. So when it was served to the defendant with regard to the proposed amendment.
Yes, that is as per my instruction goes, if I am not correct, if I am not after the before the 17th August 2020, that day it was served because it was specifically lordship recorded that they have been served. It is not that in the open court that has been served.
Court has recorded to serve the amended copy of the plaint.
Yes, lordship will
court has not recorded served. I record, this court records if it is served, it is served, it is not served, to serve within a period, whatever it may be.
May I ask this question to myself, what is
the question from
I am also only on this point, they have never disputed the address.
Okay.
Today my case is very short.
Okay.
Whether they have disputed or whether they had a knowledge on that or not. It is a case, where lordship will kindly sees, they had a knowledge from 17th September 2022, but they could have taken. And at the time of amendment, when that was from it fallen from their side that this name has been changed, but they could have objected. They see this is the problem.
Okay.
It was allowed.
Okay.
It was allowed. Today, lordship will kindly sees, if today, section 8, there was a contested hearing, they filed a after 3 or 4 hearings, whatever the order has been passed. Now, my case is that, so it was always within their knowledge that we have given a Shakespeare court.
When the section 8 application was disposed of?
That was been disposed of, before one, sometimes in the
So that is prior to the amendment.
Yes, yes. No, not prior to the amendment.
Not prior-
After.
After
After amendment, man, they appeared. After that, the first thing they did section 8.
I'm asking when
Yes, yes,
it
ma'am.
was heard and when it was disposed of. Show me.
Yes, malab. Only give me a second, madam.
Section 8 was filed on 12th day of
Yes.
October.
Well, 12th October 2023, section 8 was filed.
2024.
Yes. So, malab, they filed section 8 on 12th October 2023. There is an endorsement. Malab.
12th October
2023, they have filed the malab section 8 application. Malab. GA3, man. Now, malab, in that malab, in that malab, they have also malab, totally malab, what they have done, malab, Lordship will kindly see is malab, they have specifically taken only the arbitration clause point and nothing else.
How?
Yes.
Like September, the time change.
Yes. Now, malab, Lordship will kindly takes malab that. After that, malab, section 8 has been malab disposed of. No. Oh, sorry.
After 17 hours.
Yes. Sorry. Malab, after 17th August order, malab, there is an order dated 21st September 2023. Malab, that your Lordship has recorded, malab. Counsel for the defendant prays for extension of time to file the written statement in the suit, as well as the affidavit in opposition in connection to GA1 of 2020. It is found from the record that by an order dated 17 August 2023, the defendant had been allowed to file the written statement as well as an affidavit in opposition, but unfortunately, the said order has not been complied with. For interest of justice, as a matter of last chance, time to the file written statement as well as the affidavit in opposition extended for a further period of 2 weeks.
Order dated?
My order dated, my lord, 21st September 2023. No. And now, my lord, yes. And my lord, after that, my lord, October 18, 2023, for the first time it came to the knowledge, defendant has submitted that the defendant has filed an application being GA number 3 of 2023 under section 8 of the Arbitration and Conciliation Act, and the said application is fixed for hearing on 12th December. In view of the submissions, the counsel for the defendant, yes. Now, my lordship, I just want to point out before a lordship, my lord. So it was, they could have, on that very date, they could have taken this point, my lord. Well, who has stopped them from taking this point?
Yes.
Knowledge, lordship, I have showed before your lordship from mediation proceeding. Why mediation? I am trying to show, my lord, because there were certain agreements, my lord, some letters which shows that, my lord, they were trying to complete the mediation process. Now, after this, my lord, application was allowed, my lord, but they have not taken any steps. From 17th August 2023 until July, what is the delay that has been? There is nothing in respect to that. Now, this application has been filed. Only whether this is maintainable in the eye of law, that is also a point of that I am taking. Okay. Now, in respect to that, lordship, judgment of
Yes, next.
I'll be only citing 2008 to SCC, page 3. It's a copy, it's a complimentary copy has been given for the page number. Yes, sir, page 326. 26. Now, page, paragraph 20, I'll show paragraph 23 first. Paragraph 23. It is therefore clear that the legal position under the amended code is not whether the defendant was actually served with the summons in accordance with the procedure laid down and in the manner prescribed in order 5 of the code, but whether he had notice of the date of hearing of the suit and whether he had a sufficient time to appear and answer the claim of the plaintiff. Once these two conditions are satisfied, an ex parte decree cannot be set aside even if it is established that there was irregularity in service of summons. If the court is convinced that the defendant had otherwise knowledge of the proceeding and he could have appeared and answered the plaintiff's claim, he cannot put forward a ground of non-service of summons for setting aside ex parte decree passed against him by invoking Order 9 Rule 13 of the Code. Since the said provisions applies to the debt recovery tribunals and the appellate tribunals under the Act in view of Section 22(2)(g) of the Act, both the tribunals were right in observing that the ground raised by the appellants could not be held. It was not given content in the appellants that though they had knowledge of the proceedings before DRT, they had no sufficient time to appear and answer the claim of the plaintiff's bank on the ground ex parte order deserves to be set aside. Now, my lord, in this case, my lord, what I am trying to show is before your lordship is that, my lord, proceeding, my lord, if today, my lord, I take it from your lordship, my lord, if there is some, my lord, defect in also, my lord, service of summons, my lord, once, my lord, it was their knowledge from mediation proceeding, the address I have also, my lord, showed the summons. Yes. But they have filed a vokalatnama, they have received them, whatever may be the, my lord, they have received it, but they could have taken that point at an earliest opportunity, my lord. They have filed a section 8 to that effect. After the lapse of the time, my lord, today, my lord, they have come with this plea, my lord, only to get an opportunity to file a written statement, my lord. My lord, lordship knows, my lord, this is a commercial suit, so they cannot be allowed. Now, my lord, what
is the stage of the suit?
Nothing has been done.
What is the stage of the
suit? We have only filed an injunction application. After that, my lord, they have filed this recording application, my lord. So this is the only pending on this. Only another, there's the HT Media versus Brainlink International. This is a unlisted. Unlisted. Yes, the commercial score judgment. Copy that. Paragraph yes. Paragraph 13, my lord, will kindly text. This has been Sunil Poddar has been yes. Lordship will kindly text, my lord. The Supreme Court, paragraph 13. The Supreme Court in Sunil Poddar has the occasion to consider this question, no doubt, in the context of an application under Section 22(2)(g) of the Recovery of Debts Due to Banks and Financial Institutions Act 1993, read with the Order 9 Rule 13. Nevertheless, the observation made therein would be relevant here. In that case, it was held that the question is not whether the defendants were actually served with the summons in accordance with the procedure laid down and in the manner prescribed under Order 5 Rule 5 CPC, but whether the defendants had sufficient notice of the date of hearing and had sufficient time to appear and answer the claim of the plaintiffs. It would be useful to reproduce paragraph 23 and 24 of the state judgment. This 23-24 has been laid down, so now only yes, this has been passed, you cannot,
yes. Anything next?
Now,
how much time will take further?
If
how much time will take further?
I'll take some time in respect to I'll cite some other judge will lordship fix it any date.
So appearing for the plaintiff, so appearing for the defendant. Full stop. Counsel for the plaintiff has argued at length in connection with GA.com 4 of 2024 and prayed for time. Full stop. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 24th January 2024.
Any day prior to that or after 26th.
28th January 2024.
Great for us.
Oblige.
No. আমি তো রেসপন্ডেন্ট না আমি তো রেসপন্ডেন্ট তো তা ওদিকে যেতে বলছো কেন চাপ পিটিশনের করে ওই তো
দেখবেন না Yes.
This is my application, my item 26 is my item 26 is my application, my lord. This is an application for extension of time for filing my affidavit in support of my caveat, my lord. There was a 38 days delay, my lord. My lord, I have for which I had made my application. There was exchange of affidavits, my lord. Today is coming up for hearing.
With the opposition. Yeah.
Will the reply? Have you filed the reply?
My lord, it has been filed.
So and so applying for the.
My lord, only one thing, my lord. It's 38 days delay. Now he wants a prayer for another 4 weeks to file the.
I'll not require 4 weeks. 4 weeks, 1
Yes,
week after the vacation will do. I'll not require 4 weeks.
Yes,
It's almost
to
ready.
file the caveat in August.
Don't want.
File the caveat in August, application in September.
We don't want that 4 weeks. It's
some
almost sufficient. 1 week will be
is
more than
not
more
even
than
annexed. The opposition is not even annexed to the application.
Opposition may not be
Opposition, the affidavit in support of
the affidavit may not be annexed, but all the affirmance of my affidavit in support of caveat is in my affidavit in reply. Page 3 onwards.
So and so applying for the petitioner, so and so applying for the applicant. Caveator or caveatrix?
Caveator, my lord.
Caveator. Caveator has filed an application being GA2 of 2024 in PLA 347 of 2023, praying for condoning the delay of 36 days in filing the affidavit in support of caveat. Full stop. Counsel for the caveator.
Okay. The applicant.
Submit the.
I appear for the petition in the probate application.
And for the caveator.
Counsel for the caveator submits that.
Yes.
And from
that due to the health condition and paucity of the funds and the heavy flood situation in the locality of the caveator, the caveator could not file the affidavit in support of caveat, and as such he prays for condoning the delay of 36 days. Counsel for the petitioner raised objection and submitted that there is no document enclosed with the present application to show that the caveator is suffering from any such disease due to which the caveator could not file the affidavit in support of caveat. He further submit that he has not also enclosed any document to show that by the said period there was any flood situation in the said area. Counsel for the petitioner further submit that the caveator has taken the ground of the paucity of the necessary fund, but now has engaged an advocate and has filed the present application, but has not specified in any of the paragraph how the caveator has managed the funds to file the present application. Full stop. Had the learned counsel for the prospective parties peruse the application, this could find that the caveator intend to contest the application filed by the petitioner for grant of probate, but there is a delay of 36 days for filing the affidavit in support of caveat. This court further of the opinion the cost shown by the caveator is sufficient to condone the delay of 36 days. Accordingly, the filing of caveat, delay of 36 days is condoned for filing the affidavit in support of caveat. Full stop. The caveator is directed to file the affidavit of caveat by 24.
1 week after vacation.
1 week after. 1 week after.
They should have been ready by this time.
That is the problem.
Lordship, that I found that commercial courts, what rules came in, must come with the written statement along with the application.
Not a commercial.
I read that. No, whatever. The principles, I'm not saying.
1 week after vacation, my lord.
1 week after, what will you do the vacation?
By 6th.
Vacation, it will be ready, my lord. It
By
will be
6th,
ready.
yes. With some terms.
The
On some terms.
caveat
6th.
on or before
6th.
7th of January 2025 by serving the copy to the learned counsel for the petitioner. Full stop. Let the matter appear on 9th of January 2025.
No terms.
No, my lord,
No.
not match with status.
Instructions.
Can PLA matters.
Item number 27.
Alternative is becomes expert. Yeah, alternative is expert.
Item 27, I beg to appear for the applicant, my lord, an application for grant of probate of a will which has been executed way back in 1964, a registered will. There was a delay, my lord, registered will, we have made an application. In connection with the original application for grant of probate, we have preferred an application GA1, right, for certain directions for service of citation upon the other legal heirs.
Will updated?
Will is execution of the will is of 30th June 1964.
1964. When the testator died or testator died?
Well, the testator died on 17th May 1967.
67. When the application filed?
Well, this application was filed, my lord, in 2023. 2023. Let me just 4th December 2023.
4th of December 2023. Yes.
We intend to, my lord, get
after how many years? 40 and 20, 63 years.
63 years.
Then
we have tried to explain the delay because we are not the executor.
63 years
We are not aware of the will.
And who has filed the caveat? This PLA.
The executor being the son.
Executor is alive.
Executor is alive. It's an application for grant of probate. Executor, we suddenly
not the beneficiary.
Not the beneficiary. We intend to serve all the legal heirs.
So what do you want now?
My lord, for certain directions, my lord, for issuance of citations, and also if your lordship,
GA.
my lord, initially at that point of time there was delay, and the applicant, delay in my lord, placing the matters, and my lord, the executor by this time was suffering from cancer. This GA, my lord, I have annexed the documents showing that his days are numbered. That is the reason we tried to expedite the thing and prayed for certain orders, my lord, for directions so that the citations can be issued.
That's why you file this, file the PLA December 2023, praying for issuance of praying for issuance of this citation on 2024. Then you will come with the evidence on 2025.
My lord, that is not the thing. And
will is of will of 64.
Another thing, my
before
lord,
our birth.
The attesting witness and not before your lordship. Then also we have to prove the will in.
So how you will get the witness? 64 will.
We have to prove the will on solemn form, my lord.
Payment. Who has drafted?
Lord, I take the responsibility.
None has come forward.
No, my lord. First time I'm appearing for.
How many legal heirs?
My lord, legal heirs, my lord, I have stated in.
A, B, C, D, E, F.
Yeah, my lord.
None of the legal heirs come forward.
No. Till now, my lord, we have intimated them.
For the petitioner. Petitioner has filed the present application for grant of probate of the will. Probate of the will dated. What is the date?
30th June 1964.
30th June 1964. Full stop. Counsel for the petition submit that the testator died, leaving behind 6 legal heirs, and none of the legal heirs either come forward to file affidavit of consent or to file affidavit in support of caveat. Full stop. Accordingly, petitioner has filed the present application being GA1 of 2024, praying for issuance of only general citation, special citation as well as general citation. Accordingly, prayer A of the GA is allowed. GA1 is disposed of.
Grateful.
Next.
my application, my lord, pursuant to my lord's last direction of 5th of December, my lord, we have, my lord, she has filed the vakalatnama and she has written back to us, my lord, that she has filed without prejudice to her rights, my lord, with regard to the name of the, my lord, the caveatrix. We have served her, my lord, with the PLA application also, my lord, and with the supplementary affidavit, my lord, had directed us to, my lord, file a supplementary affidavit as to whether from the second wedlock the testator had any legal heirs or not. ওটা কোথায় ঢুকিয়ে রেখেছো? আগে মোবাইলটা না দেখে তো এগুলো বার করতে পারতে। May I file, my lord? We have served on the other side. My lord, kindly takes, my lord, paragraph 4, page 2. In fact, these were some of the defects which were, my lord, queries which are raised by the department. Kindly takes, my lord, page 2, para 4.
Page 2, paragraph 4.
Para 4, yes.
Page 2, para 4.
4 of the supplementary.
No children out of the wedlock
Yes.
of testator.
This is second wedlock. The caveatrix, my lord, and with the testator, my lord, there is no legal heirs. Now, my lord, we have filed, my lord, I have also served the PLA upon her. She had accepted notice.
This time granted leave to file
Yes.
such affidavit disclosure content raised in paragraph 1 of the report. Where is the report? Here, Dada.
Report was there. My lord, now with regard to first
Testator
defect,
did not disclose whether there are any children born out of the wedlock.
that has, my lord,
Correct. Then
been done. Now, my lord, there was another defect which was pointed out, that with regard to a locker. Now, my lord, I have filed the GA1 for my lord, passing my lord's order, my lord, with regard to carrying out inventory. My lord, after the inventory is carried out, we had to file an application seeking amendment if something is out. Now, my lord, this GA1, they are opposite. My lord, we had been served with the opposition. Now, my lord, this GA1. GA1 to? GA1.
Lordship, we are not pressing that opposition.
Very well. Then, my lord,
We are not pressing that opposition as on date, Your Lordship. The PLA application was served upon us on the 18th, day before yesterday, Your Lordship. We will require some time to file our caveat and affidavit in support of caveat, and also, Your Lordship, we would like to give an opposition to the affidavit
when you
filed
receive
by
the
them.
caveat, this PLA.
PLA, Your Lordship, 18th, day before yesterday,
Time is
Your Lordship.
going to be power. You not file the affidavit. Yes.
Your Lordship, only day before
now,
yesterday.
my
we
lord,
have
with regard to
received it, yeah.
GA1, my lord, this is the my lord, my answer to the query raised by the department. My lord, we have filed this, my lord, with regard to the bank account. My lord, kindly seize my prayer. First prayer says so, my lord.
Bank manager Allahabad.
Yes. Bank manager Allahabad to cause open the locker. Yes.
Cause open the locker. Locker number is mentioned in the affidavit of asset.
My lord, that I'll include. That if my lord directs, if something is out, my lord, I'll include. Carrying out the amendment.
Which bank? This locker?
My lord, Allahabad Bank.
Which locker? Locker number?
Locker number.
Where is the locker number?
Locker number. That was, I think, one of the queries from the department as well.
Locker number
Mr. Dasgupta, it would be better to come with an application for amendment with regard to this in the affidavit of assets and with regard to this in the application with regard to one paragraph what you have submitted in affidavit. In affidavit that the testator died or testatrix died without leaving any issue. That has to be come on your application, not by way of supplementary affidavit. And this also you have to come with a proper application for amendment. Let the court see whether it has to be allowed or not. Then the
I was just trying to shorten the time.
How it can be? If this court allow also, how you can include in the application? Tomorrow this court will not be there. You will not be there. Other advocate will come. Other presiding officer will come. How they will understand?
Lordship, it is not even a supplementary. The heading is affidavit on behalf of applicant.
This affidavit, how the affidavit can be taken as a part of the PLA unless the PLA
is... my lord directed last day.
That's I directed. Yes. File it. Now you have filed it. If you filed it, so now there are two defects. These two defects has to be cured by way of affidavit, by way of amendment. That is the locker number And with regard to the no issue, that amendment is to be carried out in the PLA application, and with regard to the locker, it has to be carried out in the affidavit of assets. Come, let the copy be served, it can be decided, and let's proceed. Very well. In the meantime, if they will file the caveat, then the contentious cause will go. Very well. So and so appearing for the petitioner, so and so appearing for the.
Milad, only one thing, Milad. What I am given to understand, Milad, we are not seeing eye to eye, the contesting parties. Now, Milad, the locker number is of the deceased. Now, Milad, she is the so-called wife, the second wife of the Milad, the deceased. Let her, Milad, disclose
the number.
Yes, let her. We don't have the number. Whatever locker she, Milad, she the of the deceased she knows of, kindly direct her to.
How the court?
Lordship, everything is under their control at the moment, Your Lordship. I do not have any knowledge.
This is a very good, nice submission to get
That's
everything.
correct.
But,
It is
Milad,
there.
They may take the plea. You may take another.
I don't have the locker number. I'll not
You're
be.
not having the
I'll
locker
not.
number,
Yes,
but you know them with regard to the bank.
Yes, Allahabad Bank, I know.
So you can contact.
Milad, they will not. It's a PS Milad. It's not even a private bank. They will not entertain me. They will not, because the probate is not in my probate. We are not. I am not the successful Milad, the executor now.
So unless both give
they
the
have
consent,
to disclose.
That's why you come with that. Unless both can disclose or both can give the consent, then this court can pass an order upon the bank if any locker number.
No, let her disclose the locker number, whatever her clients knows. That's all.
They are not filed the affidavit of.
Well, at least let her file the affidavits. Then I'll take steps.
Yes, let's.
Lordship, let the amendment be carried out first.
That what you receive, madam, first you have to do first.
Yeah, state.
Otherwise, your time will go. So and so appearing for the caveat, police or counsel for the petitioner has filed affidavit on behalf of the applicant, stating the fact that there are no children out of the wedlock of the testator and the alleged Bakul Chaudhary. There are no children out of the wedlock of the testator and the alleged Bakul Chaudhary. This is in connection with the point raised by the office while scrutiny of the PLA application. As regard the point number 2, the petitioner submitted the petition is not having the locker number, and as such it is not possible for the petitioner to mention the locker number. Counsel for the petition submit that it is the caveatrix or caveator? Caveatrix who can provide the locker number. This court has inquired from the learned advocate appearing for the caveatrix, but the learned advocate for the caveatrix submitted she is not having any knowledge with regard to the locker number of the testator. In view of the above, the counsel for the petitioner submit that the petitioner will take appropriate steps for amendment in the PLA application or the affidavit and the affidavit of assets with regard for insertion of the locker number in the affidavit of asset.
Later, because otherwise I'll not be.
Let them file.
Yes, let them file.
Correct. List the mad full stop. Counsel for the caveatrix. Press for time to file. Let the matter appear on. How soon you will file? Appear on 9th of January.
I was just thinking, if I don't know the locker number, even if I come with GA2, because I'll not be able to put in that.
So you do you file affidavit. For the present, you leave aside that. See, what is the report of the department? This court cannot advise you, sir, sitting here. Petitioner has not filed the list of contents in bank locker. Either you delete it or give the locker number. There are two options.
Very well.
Either delete or to give the locker number.
But let's say if Mela takes page 20 of Mela the probate application, the will. Kindly see the first page of the will, the last 3 lines.
First page,
page 20. It's a will.
Will?
Yes. Of the PLA.
Paragraph?
Second paragraph. Kindly see the marked last 3 lines. Allahabad Bank, Southern Avenue branch locker, which consists of family heirlooms, ornaments, and old silver coin. So I cannot leave. There is a difficulty. So this has not produced the locker number. Even if I try to, I can't.
Mr. Dasgupta,
Lordship, the application that they have provided, the page numbers are not matching with my
there
document.
is also no page number. I don't know
It's
where.
9 and for them
There
it's
also
20.
there is no page number. Let the matter appear on 9th of January.
Lordship,
Mr.
Lordship,
Dasgupta.
I'll take
Lordship, one small prayer, Your Lordship. To this affidavit that they have filed, we would like to give an objection, reply, Your Lordship.
Which
The
I am
new.
not taking only this is kept on record. This court has not taken cognizance. That's why they have to take appropriate
All right.
steps.
If she has any
If they
legal
will
errors
file-
from the second order,
That's
let
why
her
if you
disclose.
file an application for amendment, if you are having some objection, no, then you have to disclose.
Let her
Or in
disclose.
your affidavit, in support of caveat, you can disclose it. No
Lordship,
problem.
not that. The other paragraph, there is another disputed question of fact that has been
that cannot
included.
be. That's why I am not taking cognizance. This
All
court is
right,
not
all
taking. Yes, 9 January.
9 January.
Grateful.
Next.
29. This is my application for letters of administration, my lord. My lord, in terms of order, my lord, I opened the locker, my lord, and inventory was made, my lord. Well, I have to amend the affidavit of asset as well as my lord petition.
You found the bank.
My lord, all has done, my lord. Inventory has been made, my lord. I have to amend only the asset and petition, my lord. I have filed the GA application today, my lord. I shall supply the GA application number, my lord. Let it appear on any day, my lord, after vacation, my lord.
So appeal for the petitioner. Police of counsel for the petitioner submitted in terms of the order passed by this court, the petitioner has opened the locker in presence of the bank manager and inventory has been made. Accordingly, the petitioner has filed appropriate application for amendment in the affidavit of assets.
My lord, and petition, my lord.
Affidavit of asset as well as the probate application. Counsel for the petitioner prays for time. Let the matter appear on 16th January 20.
My lord, please.
Yes, next.
30 lordship, this is my application praying for an accommodation till vacation, lordship, praying for an accommodation till vacation, lordship.
Why?
Because lordship, the petitioner is not well on last
Space for taking steps of beginning the name of the details of the legal heirs of the deceased testator, as well as for amendment and incorporation of certain prayers. As per the prayer made by the counsel for the petitioner, case is adjourned. As per the prayer made by the counsel for the petitioner, case is adjourned. Let the matter appear on 29th January. Next.
And I'm the plaintiff propounder.
The defendant on the last day, Lordship had granted me the last chance to complete the process of discovery of providing inspection of the documents. But after your Lordship had passed the order, we had communicated the order to the. If your Lordship remembers, this was an issue. Yes, my lord. We had communicated that order to the receiver. We had multiple telephonic conversations as well. But the last update from the receiver is that she would give a date after the 25th of December. For taking inspection of the documents lying in the office. So I would beseech your Lordship, if your Lordship kindly grants me time till the first week of January. If that is not completed, by then Lordship may appropriate
This
recourse as
has
there.
been the prayer for at least the last.
I know, Malad, that
last
is why I'm not
3 days,
saying anything.
The only thing, Malad, this is the proceedings of 2019. It has been marked as a testamentary suit in 2022. This is end of 2024.
So appearing for the plaintiff, so appearing for the defendant. Police of counsel for the defendant submitted in terms of the order passed by this court dated 20 November 2024, the same was duly communicated to the receiver.
Yes, receiver. I have the email.
Receiver and the receiver has informed the learned counsel for the defendant that she will take appropriate steps for inspection of the document after 25th of December 2024, and the learned counsel for the petitioner defendant prays for fixing the matter after 25th of December 2024. Counsel for the plaintiff raised objection and submitted that for the last several years, the defendant is taking steps for inspection of the document, but till date it has not been completed. In view of the submission made by the counsel for the respective parties, let the matter appear on 22nd of January 2025, it is made clear that by that time, if the receiver failed to
carry out the process in terms of the
carry out the order passed by this court dated 20th November 2024 for inspection of the document by the learned counsel for the both the parties.
Both the parties.
The counsel for both the parties of the present proceeding, appropriate order will be
My lord.
Receiver.
I'm grateful, my lord.
If the receiver failed to carry out the order dated 20 November 2024 by allowing the learned advocate of the parties for inspection of the document by appropriate order.
Grateful, my lord.
Lord, I appear for the plaintiff. Lord, I'm seeking my lord's liberty to appear online.
Petition in the application. The affidavit in reply. But this my application by one of the executors named in the will. The other executors, Mr. Altamas, is appearing for the other executor. So we are the joint executors in the will. What happened? We are the brothers and sisters, grandfather's will. Now, the will records that we are joint executors. His client goes ahead and files the probate application without informing me as a single executor. The probate file. Incidentally, this probate is opposed by my father only as a caveat, who is the defendant. Now, when I come to know, I'm the grandson. When I come to know, I make an application for addition of party and the simultaneous grant because I am the named executor. So the application was opposed. Ultimately, I succeeded. Now today I am being added as a co-plaintiff and I'm a co-executor, a co-plaintiff in the suit. So in this backdrop, when I...
What is the application now?
Yes, so this is the backdrop. This DS6 is the probate concerns with the property in Salt Lake. The title deeds, the sanction plan and other original documents of the property are in the custody, should be in the custody of the other executor, which is the plaintiff, my cousin sister. Now today's application is, I say, that as we joint executors, it should be now a joint custody. You cannot keep on independently. I wrote a letter to her, give us inspection of the original. Not given. No reply given also. Now I pray here, first inspection be given of the, let me see the original documents, which is in your custody, because the title documents of the property, and let us open a joint bank locker, because we can't keep it together. So let us open a joint bank locker and keep the original documents in a joint custody in the joint bank locker in a safe custody, subject to the result of the probate. Because I don't have a caveatable interest because I am not a defendant neither. I'm only a executor. This is the application today for a joint locker be opened, inspection given original, joint locker be opened, and we can retain our photocopies of the documents. This is today being opposed by the co-executor. In the opposition, he has cited many things that I am citing my father, I am whatever. So I say my application, if not my lord's pleasure to come at page 13 of the application. Page 10, the will starts. The will starts at page 10.
Yes.
Page 13, the third paragraph. I hereby appoint Pratik Kajaria, I am appearing for him, and Miss Anushka Kajaria, the daughter of Piyush Kajaria. The Anushka is the other plaintiff. So today we two are the plaintiffs as the executors of this last will and testament, who after my death shall obtain.
You both are the cousins.
Yeah, cousin. Sorry.
Both are
cousin brothers. This is Bimal, Pratik, I am son of Bimal, and Anushka is son of Piyush. The Piyush and Bimal are own brothers. Brothers, yes. The will is of father of Piyush and Bimal.
That's right.
Yes.
Grandfather. Grandfather of the executors.
Grandfather of the executor.
Yes.
Yeah, grandfather of the executor.
Correct.
Grandfather of the executor. The grandfather has made the grandson and the granddaughter are the executors. This is the order. And now page 23 is the order by which I was allowed to be added as a co-executor and a co-plaintiff by this order. This order was also hotly contested, whatever. Now, I should refer the internal page 2 of this order at page 24, running page 24, is recorded that in reply, the second paragraph, in reply, the learned counsel for the petitioner, I was appearing, has submitted that his client has no caveatable interest in the property, and as such, his client is bound to support the grant, and he cannot act beyond the direction of the testator as contained in the relevant will. That has to be, because I don't have a caveat. My father may have a caveatable interest. The learned counsel for the father submitted that he has made this submission on instruction of his client.
Who is appearing for the father?
Father.
My lord, I am appearing on behalf of the defendant, my lord, who is the elder son of the deceased.
Yes. Then
now there is a letter which I write in 26 for giving inspection of these documents. This is the letter of, and so I write to my advocate on record to the advocates writing each other, madam, on 10th of May.
So death certificate is not enclosed here.
The photocopy is enclosed.
Why? Photocopy.
Generally photocopy. Okay. Whatever, death certificate may not be of importance, but from point 2 to these are the most important. Because there are multiple sanction plans.
So these are the affidavit of assets in the.
No, this is asset is only with regard to that BJ 86. This is the property. Yes, this is the property.
These are the.
This is only one property.
This is the property. What is the one property that is connected with this all document?
Minor. So this is the copy of the lease deed, the Roman 4. Copy of the lease deed in respect. I'm on stamp in respect of the premises BJ.
License number BJ 86.
Yes. 2. So all connected documents are in connection with this property only. The sanction plan, completion certificate, possession certificate, this property only. So and this is not answered yet, my lord, this letter. So I pray that my prayers before your lordship that the original be given inspection first, and we can open a joint bank locker and put it in the bank locker. So
yes, who is opposing? Mr. Alim?
Yes, my lord. My lord, yes, my lord. My lord, my objections are, my lord, twofold. First of all, my lord, my affidavit.
Not seriously opposed.
No, seriously opposed, my lord. This application is being seriously opposed. My lord, your lordship has the affidavit in opposition, my lord. My lord, my clerk has handed it over, my lord, to my lord's officer. Yes, my lord. Yes, my lord. My lord, the dispute, my lord, circles. This plaintiff number 2 is the son of the defendant.
Correct.
Now, my lord, very surprisingly, the father is opposing the will, whereas the son is coming and saying that no, the will is a genuine will.
Correct.
Now, my lord, after when we opposed the application for addition, their admission came out, my lord, with respect to that they are going to support the grant.
Correct.
Immediately after that order, my lord, this application, my lord, was filed wherein he had sought for some documents to be produced. Now, my lord, before that, my lord, the same documents the father had asked the defendant, which, my lord, I don't know why was not told. Your lordship may kindly see page 19 of my...
Okay, you are having objection with regard to he will serve the document to the father. That is your contention. Correct?
Yes. Other contention is, my lord, that the trial is being delayed unnecessarily, my lord.
Correct. Now, neither trial will be delayed. What are the documents you submit in the submit here? It will be kept in the seal cover in the record.
Absolutely.
Only at that they will only the counsel for the other plaintiff will inspect, and this will be again it will be sealed and kept in the record.
My lord, I don't have any objection in doing that, but my lord, what has the necessity that has arisen, my lord, right now for my lord, me
connected with the property which is included in the will. So
yes, ma'am.
Tomorrow, if this court is granted the probate in the joint name of both the plaintiffs, then it will be difficult. That's why let the documents be kept in seal cover. You produce it in the seal cover. It will be taken in the seal cover in your presence. Only the counsel for the plaintiff and the plaintiff will inspect this. Neither it will be taken a photograph, nor it will be xerox, and again it will be sealed and kept in the record.
Very well, but my lord, but your lordship may kindly do not record, my lord, that the originals, my lord, whatever we have, we will submit, because some of the documents there might be we don't even have the originals.
So you when you filing I am passing an order. If you're filing, then you give the affidavit that original is not there.
No, but in that event,
some originals we do have, but some we might not have. That is what I'm saying.
What are the documents?
Yes, lordship will kindly come to application paragraph 7.
At page 19 also of this AO, my lord, the order records.
Original death certificate. Okay.
The original sanction plan must be.
Original death certificate might be, because original death certificate is required in future for all purposes.
Lord, in that regard, will it be my lord's pleasure to kindly keep it on Monday? I'll take instructions which original.
No
and then I can come and then my lord, I can come before my lord.
take instruction. What are the
Very
documents
well.
available, and make sure you file this along with the affidavit in the seal cover. You come
Along with the affidavit. Very well, my lord. In the seal cover.
along with the affidavit, and if the original is not available,
Very well, my lord.
come with the affidavit and seal cover, and it will be come. And if you want to inspect, it will be inspected in your presence. Only the counsel for the plaintiff number 2 and the counsel will inspect the, and again it will be resealed.
Very well, my lord. Very well. Your lordship may kindly keeps it on Monday. I shall come up with instructions.
Tuesday.
This is the last day.
Tuesday. Monday.
Or else on second, my lord. Or else on second. Only 1 week.
Whatever.
Prayer made
Not
by
on
the counsel
Monday.
for the plaintiff number 1. Let the matter appear on 24th.
Monday already.
Yes,
Lord,
what is
Lord, instead of 24th, can it be second?
only you take instruction. Only you take instruction. Come on 24th.
Very well, Lord. Extremely grateful.
Then I'll pass an order when your affidavit is required.
Required. And what are the originals you have? What are originals and what are
Yes, next.
Extremely grateful, Lord.
For the petitioner in this matter, this will take some time in it. We have only 5 minutes.
What is the matter?
This is for revocation of probate.
When
That
it
is
will
being
take?
done.
I am fixing another. Who is for the other side?
But I appeal.
So I am fixing a date in the month of February.
Yes.
Date and time.
January or February.
January, there
whatever.
is not that. I can fix, but you will not get
No,
the
no.
date and
Then
time.
it's as your lordship.
Especially
So
fix,
that this matter is taken.
can
up,
be
yes.
taken.
Yes, yes.
Otherwise, again.
Otherwise, again, the same thing happens.
Same.
Yes.
So appearing for the plaintiff, so appearing for the plaintiff, no, so appearing for the petitioner, so appearing for the respondent, full stop. The full stop. It is submitted that pleading in connection with GA1. It is submitted that pleading in connection with GA1 of 2023 is completed and is ready for hearing. In view of the submission made by the counsel for the parties, this is the matter. Give the date. 14th February at 3 p.m.
With love. Yes.
Rose.
Roses become very costly that day.
So that's a 2 months before the date is given.
Yes. Given cheap. Lesser price.
Yes, next.
I appear on behalf of the petitioner, Your Lordship. I'm praying for an accommodation to keep this matter after the vacation, Your Lordship.
Why?
Your Lordship, both the attesting
made ever-
witnesses have passed away, Your Lordship.
Two
And
attesting witness, the petitioner is not in position to bring the said attesting witnesses, both the passed away. The petitioner made appropriate averment in the application as said the petitioner intend to prove the will solemn form. So I am fixing a date for evidence.
we still haven't taken proper instruction from the client.
As per the prayer made by the counsel for the sense appearing for the petitioner, full stop. As per the prayer made by the counsel for the petitioner, the case is adjourned. Let the matter appear on 22nd January.
Grateful, Your Lordship.
Yes, next.
Milords, may I please? Milords, I appear on behalf of the executor. Milords, my application seeking probate of last will and testament of Sri Kumar Daga, Milords, who is the testator. Milords, the testator died on Milords 4th October 2021. Milords, he survived by 3 legal heirs. Milords, son, wife, and daughter. Milords, wife and daughter.
Ready?
Milords, ready. All caveats are discharged. Milords, only the probate is to be granted, Milords. I'll just
Where is the will?
Milords, the will is at page 11, Milords. The legal hires are indicated at page 13, Milords.
Let me. Will, where is the
Will is at page 11, Milords. It is an authenticated copy, Milords.
page 11?
11.
Original will, where is original will?
Milords, we don't have the original will, Milords. This is a registered copy, Milords.
Maybe.
Milords, in terms of section 237, Milords.
But this code is having some other opinion. If it is a Xerox or certified copy or the registered will, you have to prove this in the solemn form.
Very well,
Have you lodged the complaint?
We have lodged a
So
complaint.
that is to be proved.
Very well. I'll do that.
That is
Then
to be proved.
very well. We'll prove that.
So appearing for the petitioner, police of counsel for the petitioner submit that the original will is lost and the petitioner is relying upon the
Authenticated, registered
certified copy of the registered will. But this court is of the view that the petitioner this court is of the view as the original is not on record and the petitioner is not in a position to place the said original as the same is lost. Accordingly, the petitioner is required to prove the will in the solemn form.
Very well. We'll bring the executor
Prove the
to.
said will in the solemn form. Full stop. In view of the above, the case is adjourned. Let the matter give the date for witness action. Let the matter appear on. Bring the witness on
Very
the day. 17th February.
It's January sometime.
3 p.m. 3 p.m.
In sometime in January.
January, no date. If you want, I fix it, but no date will be given. Then your witness has to wait here for
Very
the
well.
whole day.
Deeply obliged.
36.
My lord, I am appearing for the petitioner. This is a petition praying for grant of probate matter. The name of the deceased testatrix is Gauri Ghosh.
Ready?
Yes, my lord.
No caveat.
My lord, there is one legal heir and he has given consent.
That's why no caveat.
No, my lord.
Yes, where is the will?
My lord,
Gauri Ghosh statistics.
Yes.
Gauri Ghosh.
Gauri Ghosh deceased testatrix.
Statistics.
Page
Yes.
14.
Where is the name of the executors?
Executor, my lord, Rajkumar Jalan and Hira Devi Jalan. Joint
Rajkumar Jalan, Hira Devi Jalan are the executor. Where is the executor's word? Settled
My lord.
property date, so. Where is the executor? Name is there. Where is the executor appointed as the executor?
My lord, kindly see page 14, page 16. Page 16. First, second, third
As
paragraph.
executor. Yes.
Page 16, third paragraph.
Rajkumar Jalan,
Rajkumar
Hira Devi
Jalan
Jalan.
and his
They are the
wife.
two executor.
Yes.
One executor, one executrix.
Executor.
And how many legal layers?
There is one legal heir, Suman Ghosh.
Suman Ghosh. And
He has given consent.
when she died?
My lord, 22nd February 2018.
When the application is filed?
My lord,
2022.
5th December 2020.
What about the husband?
My lord, he has died.
Where is mention? Where you mention?
My lord,
2012.
yes.
Yes.
Page 3.
Yes, got it. And attesting witnesses?
Attesting witnesses, my lord, there is two attesting witnesses. There are two attesting witnesses. One of the attesting witness has affirmed Shashanko Shekhar Sarkar, page 11.
So Sansa Sarkars. And where is the affidavit of the video? What is the name of the this? Sushma Ghosh. Where is the affidavit of Sushma Ghosh?
Sushma Ghosh?
You file the affidavit?
No, my lord.
Then?
Sushma Ghosh or Suman Ghosh?
Suman Ghosh.
Suman Ghosh is a legal heir. He has given consent.
Where is the affidavit of consent?
My lord. No. My lord. Suman Ghosh.
Record. So opening for the petitioner. Full stop. The petitioner has filed the present application for grant of probate of the last. Yes. For grant of probate of the last will and testament dated 5th of July 2021. 5th of July 2021. Executed by July 2020, 2021, just 2012, 2012, which was notarized on 6th of July 2012, 6th of July 2012, executed by the testatrix Gauri Ghosh, Gouri, Gauri Ghosh. Counsel for the petition submit that the testatrix has appointed the petitioners as executor and executrix of her last will and testament. The testatrix died on 22nd February 2018, leaving behind only one legal heir, that is son, namely Suman Ghosh. Counsel for the petition submit that the husband of the testatrix was the predeceased to her, who died on 16 December 2012. Counsel for the petition submit that the legal heir of the testatrix and the sole legal heir of the testatrix has filed his affidavit of consent, stating that he has no objection for grant of probate, no objection for issuance of probate to the petitioners as per the will, as per the last will and testament. Full stop. The testatrix has executed her last will and testament in presence of two witnesses. Out of the two witnesses, in presence of two witnesses, out of two witnesses, one of the witness, namely Shashanka, Shashanka Shekhar Sarkar, has filed his affidavit confirming that the testatrix had executed her last will and testament in his presence and in presence of the another attesting witnesses by appointing the petitioners as executrix while possessing good health and fit state of mind. Counsel for the petitioner submit that the petitioner has proved the will and is entitled to get the probate. Consider the submission made by the counsel for the petitioner. Full stop. Perused original will, comma, death certificate, comma, affidavit of Suman Ghosh, comma, affidavit of the attesting witness, and affidavit of attesting witness. Full stop. This court find that the legal error of the testatrix has categorically stated that the testatrix has executed the will by appointing the petitioners as executor/executrix, and he has no objection for grant of probate. Full stop. The attesting witness in his affidavit has also categorically stated that the testatrix has executed her last will and testament in his presence by appointing the petitioners as executrix of her last will and testament while possessing good health and fit state of mind. Considering the above, this court find that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to grant probate to the petitioners of the will of the last will and testament dated 5th July 2012 upon completion of all formalities at the time of grant of probate, comma, the copy of the will be made part of the will. PLA number so and so is disposed of. Next.
I am for the executrix, my lord.
37. What is the GA?
I have filed the GA number 1 for invoking power under section 76, my lord. There is a mistake of the name of the husband of the executrix
in the will.
And on one place, and in the other place it was corrected. Now, my lord, that's why, my lord, this application is filed, my lord. Probate has been granted on January 2024, my lord. But, my lord, for that reason, my lord, there was a difference in the name. So, my lord, I have made this application with a prayer to invoke section 76 so that the description may be corrected, my lord.
Yes,
my lord,
I have, my lord.
Who are you?
My lord, I am an intervener in this application, my lord, stating that the will itself, my lord, contains certain portions, my lord, which the my lord testator did not have a sole right, upon which, my lord, I have, my lord.
So who are you?
My lord, I am a co-owner of the of some of the properties which has been mentioned to be their sole properties and which has been, my lord, injuncted, and suit is going on before the, my lord. No, my lord, what happened, my lord? This portion, my lord, will find, my lord, kindly takes up my.
It will take time.
They have nothing to say with
That's
regard to
why
will, my lord.
I had to heard it.
My lord, he has no access to will. He is anticipating. This is his application.
No, my lord, kindly see, the garage has been mentioned.
Have you filed an application for intervene?
Yes, my lord.
Yes, my lord.
That is J2.
But, my lord, that has no connection with my application, my lord.
Correct. But intervener, on which process?
He is not claiming any property, my lord.
No, I cannot.
That the court has to decide.
My lord, he is not. He is admitting.
Sir, whatever it may be, he has filed one application, whether he is having the right or no right. This court has to decide. For deciding the case, the court has to give hearing to the parties. You are saying that he has no right. He is telling that he
No,
is
no,
having
my
a
lord.
right.
He is saying he has no right. He is saying he has no right to contest the will, the probate case.
No, no.
He is
Part of the
anticipating.
property is
He is
included.
telling that the part of the property which
That
he is
is
having the
also
title.
interpretation. That is
That's
also
why
interpretation because he
interpretation.
has no access to
Now
will.
the court has to decide that.
He has no access to will. He
My
cannot.
lord, the
What is the GA2?
My lord, this is my lord. My lord, kindly sees.
Lord, say please to pass an order allowing the petitioner to intervene in the pending probate application disposed of.
Yes.
Pending probate probate is the disposed of, sir. Either you are having other options.
And he has exercised. He is telling that he is exercising such right.
And he
before
comes to the
court.
page 7 of your application, prayer portion.
Yes, yes.
You are telling that you may be allowed to intervene in the allowing the petitioner to intervene in the pending probate process. Pending probate is allowed.
My lord, actually, my lord, we are, my lord, not the persons who are interested in the will, in that sense that if the will is not there, I will be getting the property. This is not our case, my lord. My lord, there is some portion of the, my lord, property which is a common property has been incorporated in the will, and to that, my lord, a proceeding was going on before the my lord
Is the
court.
party?
Yes, he was a party.
Correct.
He was a party, and the testator himself was a party when he was living.
Correct. He is the party.
Yes.
And you are claiming that some of the part of the property which is the probate granted to him as per the will, and you are challenging that you're claiming your share in the said property. What you are telling that?
No, that is a common
Correct.
property.
So this court cannot decide the title. This court has already granted. So you, what is the probate? What is probate is only with regard to the will was executed in any suspicious circumstance, or whether he has proved or not. That he had done. Now, with regard to the title, you already filed a suit. He is a party over there. You want this probate. This court cannot give advice by sitting here. What is to be done in the suit after the grant of probate?
But actually, we are
So
not
now
aware of this will.
Huh?
We were not aware of this will.
Correct. If now you came to know, with the probate also. Correct.
Yes.
So what steps you have to taken in the civil suit?
My lord, this is just now, my lord, we have taken, my lord, we have come to learn very recently. And after that, my lord, we have.
I am disposing of this, giving a liberty to take appropriate step before the appropriate forum.
My lord.
Correct.
Because my lord kindly sees the last portion of the order, my lord, passed by this honorable court at page number 35. This is an order of status quo.
This is your civil suit, no?
This is in connection with the civil suit.
Civil suit.
My lord, this is pending since my lord, paragraph 21.
Since the very old 1997.
Yes.
Civil Judge Junior Division.
Junior Division, 8
Director expedite the
so
case.
it's pending, my lord.
Correct.
Before the, and my lord, this Rohan Shur, my lord, who is one of the, my lord, parties, as we have gathered, my lord, he is also incorporated in the suit. My lord, my lord, kindly sees. So, my lord, paragraph 20, page 22. 6B. 6B, Rohan Shur.
Is the petitioner here?
Yes.
Is the executor here?
He is the executor, and another, my lord, I have, my lord, just still Soumitra Kapoor. That is page 21. My lord, they are now saying, Lord, we have got no knowledge that Soumitra Kapoor.
Soumitra Kapoor.
Yes, 4A.
Soumitra Kapoor, wife of Rajiv Kapoor.
Yes.
So Rohan Sur is the only executor here.
They are both are the executors.
Both are there.
Yes, yes.
Both are the executors.
Executors.
Joint executor. And where is the will?
My lord, will is not with us.
No. Where is the will?
Will is annexed with my original application, my lord.
GA1, kindly come to the
yes, my lord.
Which
GA1,
portion?
it is also.
Which portion he is relying upon?
My lord, GA1, it is page 14, my lord.
Page 14, yes. Which portion is relying upon? Which property is relying upon?
My lord, the garage portion, my lord, which has been constructed as treated as a part of 69C, which has been granted in the will.
My lord, in 69C, my lord, there is a 3-story building.
Where is that?
My lord, if your lordship kindly come
Affidavit
to
has
page
that?
number 15, my lord.
1-5.
My lord, on 1-5, my lord.
Yes.
My lord, in will itself it is stated.
Where is
I
that?
hereby bequeath, my lord, from the
Where is
second
that?
paragraph. Second paragraph, my lord. My lord, in the first paragraph it is written, I am the sole and absolute owner of 3-storied building.
Yes.
Being premises number such and such, I am also the absolute owner of a generator room in the open space
Correct,
behind the
sir.
aforesaid
See,
building on the north
see,
side.
this will has been probated.
Yes, my lord.
Correct. Now you got the probate.
Yes,
Now he is already and in the suit which you have filed. That suit, this is the property.
My lord, the garage.
There is a schedule of property in the suit.
Garage, my lord. My lord, the plaint is not annexed anywhere, my lord.
In the suit which you have filed before the Alipur Court, Civil Judge Junior Division, whether 69C Rajbihari Avenue is the schedule of property
No,
over
my
there.
lord. This 69C does not include the garage, which is, my lord, constructed. My lord will kindly see, come to page 15 once, my lord. Once.
I am
That
there only.
page 15.
Page 15.
Page 15 of my application.
Your application.
There.
Yes.
My lord, this is an identical application, my lord. This is the my lord, the deed of gift of Brahmananda Shur, who was the testator before your lordship. My lord will find from the deed of gift, my lord, the same schedule. Schedule is, my lord, map is annexed there too. I am the, this is my property.
Given, my lord, the deed is not given, my lord.
My lord,
That has not been entered. And my lord, the pending
my
suit,
lord,
my lord,
kindly says, my lord, this 12-foot wide common passage, which is
Okay,
in
now
front of.
time is over. I am fixing it. So and so appearing for the petitioner, so and so appearing for the intervener. The petitioner has filed the present application being J1 is your application.
Yes, my lord.
Praying for correction of the name of the father of the testator.
Wife of the executrix, my lord.
Wife of the executrix. Wife of the executrix.
Husband of the executrix, my lord. Sorry. My lord,
Husband of the executrix in one of the paragraph of the will.
at first page of the will.
In first page of the will.
Yes,
Full stop. The intervener has filed an application being GA2 of 2024, praying for allowing the intervener into PLA number 623 of 2022. Full stop. As though the counsel for the respective parties are argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 29th January.
29th. 29th. I'm deeply upset. For the
And I appear for the defendant, the state, my lord.
I'm appearing for the plaintiff, Lordship.
Mr. Shah was making his submissions, and I don't know, he's not in town, so I've come in, my lord. My lord, if I may just tell your lordship very briefly what I'm sure Mr. Shah has told you this. The portion he hasn't argued, I will argue today.
Yeah.
What has happened is in this suit, my lord, the plaintiff is a contractor. He was to do some civil works, my lord, regarding a cross bandh. Basically, it's an aqueduct where the two levels of the river are to be adjusted. They were to repair that. So, my lord, this contract was only for 2.5 months. So it was given in some time, according to us, in February, and the dated February, but it served on 3rd of March. 4th of March, I'm sorry. 4th of March. And they were to commence work from 6th of March. So then the contract was for 2.5 months. According to them, they started work on 24th March. Each party has blamed each other for this late start. And it continued, it was extended. Then there was two incidents, separate incidents, one with the local people.
Agitation.
There was some agitation, that was for 1 day. And then another boy drowned, unfortunately. And then, my lord, there was another delay for another few days. We've given extension for 5 days. Even then, my lord, the work was ultimately completed in August. So it was to finish sometime in the end of May, it finished in August. So it was a 3 or 4 months, there was delay. Now, our endeavor will obviously be to show that that delay is not attributable to us. Nor have they been able to show. They have also used these instances, these local agitation, etc. That's not attributable to anyone. But if it is not attributable to me, that prolongation is not due to my fault. That's the first point. Because their main claims are in damages. Now, damages has two parts. One is they have to prove that I have committed breach and the to show the liability is mine. Second, they have to show the quantum of damages after proving that they have suffered loss. This is very basic. So when they gave a final bill, there was only one bill. It was a very short period. It was only a 2.5 months contract. The first running bill was treated as the final bill, and we paid them. And in the receipt, it is recorded, paid in full and final settlement. And the matter was over as far as we were concerned. Then, my lord, then they filed a suit. That time there was no arbitration clause. They filed a suit. In the suit, my lord, their claim is that the value of the work they have done is 24 lakhs. We have paid 12 lakhs. They admit that we have paid 12 lakhs odd, but they say that that receipt, which records full and final settlement, was given to us in blank. We filled in the figure, and they have the first three prayers in their suit is a declaration that this receipt is bad. And my first point, therefore, will be that they have not proved that this receipt was fraudulent or forged. No particulars of fraud also have been pleaded as such. And Manoj, they have not proved that who has put this figure. What they say is they had given a typed receipt in full and final settlement with a figure blank. And we have typed out the figure. Now, that has not been proved who has typed out the figure, but their allegation is you typed it out. But if they gave me a blank receipt, I was entitled to. So I am at a disadvantage because I managed to see Mr. Shah's argument on YouTube. But when they have argued, I do not know. But at least my learned friend assures me no cases were cited. So I'll be relying on some principles of law and cite a case. So one of the first part is that the first three prayers are relating to this particular document. Now, in my submission, Manoj, first that they have not proved it, therefore that is full and final settlement. That's a complete defense to their claim for outstanding works are concerned. Second is, even if they prove, even if your lordship ignores that document, they have admitted receiving 12.52 lakhs. So that is admitted. Now the question is that the remaining 12 lakhs that remains, That, according to them, was a supplementary work. And this was exactly what Mr. Shah was showing the evidence and the pleadings to my lord to show that it is their case that this was a supplementary claim. And our defense to that, to cut short, I'll go through the details and show your lordship the particulars of the pleading and evidence. But our basic case is that if a supplementary tender is to be relied upon, it has to be signed by both parties. It has to be a written tender. Now, some extra work can be done and the superintendent can allow them. And our case, from the evidence, I find that they have done some and we have paid. About 1,80,000, they had done some extra work and we have paid that. That is not in the calculations of my learned friend, the learned friend's client. So, my lord, three parts, again, I'm repeating. First is this 12 lakhs claim is outstanding.
Yes.
Second part, they've asked for interest at 24% per annum compounded quarterly.
Okay.
Now, there is no agreement for interest at all.
Yes.
And it is exorbitant. And for those 3 months, they've totted up a claim of interest is over 8 lakhs.
Yes.
Now, this is completely an arbitrary claim. They have to first prove that the delay was in my fault.
Yes.
And according to us, when the bill was raised, it was paid in time and paid in full.
Yes.
Now, if anything else is adjudicated upon, well, the interest can never be compounded.
Yes.
Once the suit has been filed, at least, there's no agreement for compounding. So that interest claim, my lord, I will say it goes completely and ultimately is the discretion of the court, if it is found that some money is due to them. So out of their claim of 40 lakhs, 8.6 lakhs goes on interest. 20 lakhs is for damages. Now, I will deal with that part because Mr. Shah has dealt with, and I saw his submissions. He had said he will give my lord a written note. I have prepared my note in my way, but the page numbers, etc. So I'm not really venturing today into the details of that supplementary. Of course, the broad defense I will argue.
Yeah.
Now, if my lord takes paragraph 57, which was shown to my lord of the plaint.
Fine. 57 of the plaint. 57 of plaint.
Yes, ma'am. Plaint. Paragraph what of the plaint? Paragraph 57. That's at page. Page 39. I don't know if my lord has a typed copy because it's very, it was very blurred.
Typed copy.
No, is it legible, your lordship's copy?
Legible.
Because we have prepared a separate typed copy of this.
Having legible copy.
Yes, ma'am. Then it's fine. But, so if my lord comes to this, I'll come back to that. Paragraph 57.
That is the claim, particulars of the claim.
Yes. So your lordship will see that they have asked D and E. So first they say that the executed work was 24 lakhs. I'll quickly make my submission. They have not proved this amount. The part of this, the 12 lakhs, then interest they have asked before we made the payment from the date of the bill, which cannot be. There has to be some time. So they have asked for interest at 24%. I'm ignoring the interest for a moment. Then C is they've accepted we have paid them this much. Even the evidence of the witness will show we paid them in 3 tranches, 5 lakhs, 54,000 and 2 lakhs something. And the rest was for the materials we had given them. And they were to pay us back for that. That it was adjusted. So this amount is not disputed. Of course, the next D, interest, is disputed. Then damages suffered due to reduction of measurement and not recorded in measurement book, 10 lakhs. And business loss, 10 lakhs. These two, there are no pleadings, first of all, in the plaint to support this, nor any evidence has been given.
Yes.
And that is why I inquired whether the plaintiff has relied on any judgments, etc. and what argument they made. Because as far as the pleadings are concerned, what is the loss, why have they suffered loss, etc., they have not shown at all. And this dispute regarding measurement book is really different from their claim that these claims, they made a supplementary tender. So it's contradictory in a way. What they've done, my lord, is in the evidence from the plaint it appears, they say that they have got an internal letter from one Boshak, Oshim Boshak, who has written to their superiors saying that I was made to change and reduce these measurement books writing. But they haven't called this person as a witness at all. They have not tried to prove it. On the contrary, the report was called for, and we have submitted a document which says clearly that he had intentionally inflated the amounts, and it was corrected. So according to that correction, this 12,53,000 has been paid. Now it was for my learned friend to show that which is the supplementary tender, was it ever accepted, and how what are the particulars. It's not like it's a big bill for 24 lakhs and we have paid off 12.
Yes.
This claim for supplementary, but again, that is the other issue, my lord, which already some evidence has been shown to my lord. I'll come back to that finally if there's time. But the damages, I'm on these two damages. There is from the evidence again. Nothing. But we have perused it subject to correction. My lord, there is absolutely no effort made to prove business loss. They would have had to show that we had these business opportunities in these 3 months, I could not go, etc. So on that account, straight away, my lord, I want to cite those 3 cases. Unibro, and Batliwala, the 2 latest Supreme Court cases, which really states the fundamental principle that you have to prove your damages. You have to first prove you suffered loss, then you have to show the quantum of damages. Well, these 2 decisions formally I'll cite. So if I can get rid of this 20 lakhs and 8,60,000 interest, all we are dealing with in this matter is this 12 lakhs. And then the only question will be, because out of 24 lakhs, 12 lakhs 53 they admit.
Yes.
So the compass of this suit is really, it will boil down if I can show that these 2 claims have not been seriously argued or tried to be proved, it will boil down to that 12 lakhs. And from 97, these suits continue and the state is happy to adjourn it, but at the end they suffer the interest for it. Because these amounts, the amount the state pays in litigation, they can easily be sat across the table and adjusted. But unfortunately, what is recorded in these judgments as well is when the contractor makes the claim, they just make an inflated claim and take a chance.
It has to be proved.
So that is the thing. That is why these litigations go on for so long.
Their main contention with regard to the correction and alteration in the
measurement.
They are relying upon that one aspect. Second, with regard to the full and final settlement. These are the 2 main arguments made by the plaintiff. And because her contention is that at the time of execution of the work, the concerned officer was there and the measurement book was prepared, it was recorded, and as per this, they have executed the extra work and she is indicted. But subsequently, the other officer has come and it has been deleted.
And it was the evidence of the defendants which proves that.
Yes. The other witness, your official witness came and said, yes, it has been submitted.
No, that letter we've given, that it was corrected again. It was first reduced and then it was recorrected and the old figures were put.
But
and that document we
with
put.
regard to the correction, whether the notice was issued to the contractor, that is to be seen. What is the rules of the measurement?
No, that is the natural justice demands that, my lord. But I think the witness has said, I have only read it very quickly. The witness has said that no, we did not inform them when it was recorrected. When he was caught, it was not. Now, what I'll tell my lord, frankly, that what I could not assess is whether that reduction is the 12 lakhs they are talking about, because this correlation doesn't appear from the plaint and the evidence also. They have said we have raised 2 supplementary. I'll show that evidence. We have raised 2 supplementary tenders. Now, whether that is permissible till it is accepted in writing, whether those tenders are valid or not is the question. So, if my learned, at least in the deposition, it's not very clear that my supplementary tender was in relation to ABC. This ABC was reflected in the measurement book, but you have unilaterally deleted it. Then as a matter of principle, I can understand the case. But as far as the evidence is, to show that this thing for 10 rupees per square foot was deleted from this and this related to that, this correlation.
That is only the case they have made out. Now,
so that correlation, so since my learned friends haven't given a note for argument in that sense, so I am at a disadvantage on that, but I will try to show, of course, that it is not, because that is our case, that it has nothing to do with that. This measurement is in relation to the main work, and the supplementary tenders, whatever supplementary work they have actually done, we have paid them. And this deletion does not correlate to the supplementary bills. I will have to try and show that. But first, my lord, I want to get rid of these other 3 claims. One is the interest, compound is not allowed, not contractual, and these 2 damages claims. And the first, clean copy. And the first is reported in 2023 SCC online, SC 1366. Unibro versus All India Radio. Well, here the facts, Your Lordship, I won't trouble my lord, but what the facts were, an award was made, it was remanded back to the arbitrator. He passed the same award again.
yes,
So it is really
so held that there is no evidence on that.
yes. So really the strictures of the Supreme Court end at paragraph 13, where it says that he could not have done this. But after that, my lord, paragraph 15, if my lord comes to paragraph 15 of the judgment, the third last page, page 9 of the print. Your Lordship has paragraph 15.
Yes, yes, got.
Considering the aforesaid reasons, even though the aforesaid reasons being this arbitrator not listening to the remand, even though little else remains to be decided, we would like to briefly address the appellant's claim for loss of profit. In Bharat, it should be coking coal, Manoj.
Yes.
Bharat coking coal, this is the 2004, I have got the judgment also. This court reaffirmed the principle that a claim for such loss of profit will only be considered when supported by adequate evidence. And it is observed, this is the part I was referring to. It is not unusual for contractors to claim loss of profit arising out of diminution in turnover on account of delay in the matter of completion of work. What he should establish in such a situation is that had he received the amount due under the contract, he could have utilized the same for other business in which he could have earned profit. Unless such a plea is raised, an established claim for loss of profits could not be granted. This has not been done in our case. So he would have said that I had this work pending, I couldn't do it.
Yes.
Because you didn't give me the money.
Yes.
Or I had this work, the other claims they usually make is opportunity loss. Here it's a vague business loss, not described in our plaint. What the loss is also they haven't pleaded. Then in this case, no such material is available on record. In the absence of any evidence, arbitrator could not have awarded the same. To support a claim for loss of profit arising from delayed contract or missed opportunities from other available contracts that the appellant could have earned elsewhere by taking up any, it becomes imperative for the claimant, here the plaintiff, to substantiate the presence of a viable opportunity through compelling evidence. This evidence should be convincingly demonstrated that convincingly demonstrate that had the contract been executed promptly, the contractor could have secured supplementary profits utilizing its existing resources elsewhere. One might ask, what would be the nature and quality of evidence? In our opinion, it will be contingent on the facts and circumstances of each case. It, however, may generally include independent contemporaneous evidence, such as the other potential projects that the contractor had in the pipeline that could have been undertaken if not for the delays. The total number of tendering opportunities the contractor received and declined owing to the prolongation of the contract. Financial statements or any clause in the contract related to delays, extension of time, or compensation for loss of profit. While this list is not exhaustive and may include any other piece of evidence that the court may find relevant, what is cut and dried is that in judging a claim for loss of profit, the court may not make a guess in the dark. The credibility of the evidence, therefore, is the evidence of credibility of such claim. Then, my lord, it goes on to say that merely applying a formula, here I don't find even the formula has been attempted. A lump sum 10 lakhs has been asked, and another prayer has been made, an inquiry be held. But no evidence has been given on the basis of which an inquiry can be held.
Lordship, I believe the 80 Bridgepal judgment was cited. A copy was furnished. I believe.
I'll deal with that one. Then
Because that is the only judgment that we always rely upon for loss of profit.
But certain amount of guesswork, of course, but it has to first show there's no assumption. And here only 3-4 months in August, the usual, these cases, the delay is usually in years. Now, if this, the other decision, 2024, it is palatable. 2 Supreme Court cases, 375. What was the history? It follows this. I'll just tell you.
Paragraph?
I'll just tell my copy hasn't come. 1/6, I think. Just before where the formulas are dealt with. 15 take it again. Here also a formula was paragraph 15, if my lord comes. McDermott International refers to section 55 and 73 of the Contract Act, which deal with the effect of failure to perform at a fixed time in contracts where time is of the essence, and the computation of damages caused by breach of contract, respectively, and states that these sections neither lay down the mode or the how and in what manner computation of damages for compensation has to be made. A computation depends upon the attendant facts and circumstances and the method to compute the damages. How the quantum thereof should be determined is a matter that would fall within the domain of the arbitrator. This is without doubt a sound, legal, and correct proposition. However, computation of damages should not be whimsical and absurd, resulting in a windfall or bounty for one party at the expense of the other. The computation of damages should not be disingenuous. The damages should be commensurate with the loss sustained. Therefore, loss has to be proved. 10 lakhs just for the asking, he cannot get. He hasn't even proved that this was the percentage of my profit. This is how much delay there was. There was a breach on part of the defendant. Nothing has been shown in the evidence. Delay should be commensurate with the loss sustained. In a claim for loss on account of delay in work attributable to the employer, the contractor is entitled to the loss sustained by the breach of contract to the extent and so far as money can compensate. The party should be placed in the same position with damages as if the contract had been performed. The principle is that the sum of money awarded to a party who has suffered injury should be the same as he should have earned or made if he or she had not sustained the wrong for what he and she is being compensated. So this is the principle, that it mustn't be in the dark. They have to show. Now 23, my lord. Then they deal with the formula. McDermott had approved of this formula as a regular in the trade. But that does not mean it can apply wherever and whenever it can. Then, my lord, 23. And here they have not applied the formula in any event. Ordinarily,
with regard to first they have to prove with regard to their entitled for the compensation or damages. If the court comes, then the formula is to be taken.
But here there's no formula also. So the liability, they have to prove it was attributable to me. Yes. But the evidence shows that these are the 2 incidents they have referred to. And I will show from our evidence that there is at least 10, 15 letters where it says, 10 letters, oh, sorry, 11 letters we have found where their poor showing has been discussed. So that's a question of fact. Your Lordship will have to go in. Whose fault was it that it was delayed by these 3 months? Paragraph 23, Mala, if I may just complete this. Ordinarily, when the completion of a contract is delayed, the contractor claims that he or she have suffered a loss arising from depletion of her income from the job and hence turnover of her business, and also of overheads in the form of workforce expenses which could have been deployed. The claims to bear any persuasion before the arbitrator or the court of law. The contractor has to prove that there was other work available, which he would have secured if not for the delay. By producing invitations to tender, which were declined due to insufficient capacity to undertake other work. The same may also be proven from the books of accounts. Here, no books of accounts have been given, to demonstrate a drop in the turnover and establish that this result of this particular delay rather than any extraneous causes. If the loss of turnover resulting from the delay is not established, it is mere a delay in receipt of money, and as such, the contractor is entitled to interest on capital employed and not the profit which should be paid. So it's very well, Bridgepal says there has to be some sort of guesswork, but it also says depending on the facts of the case. It does not mean it is automatically that they don't have to prove any loss or any quantum. Now, this one more point, Mala, that if my lord sees that prayer E, damage suffered due to reduction, like my lord said, their complaint was it was reduced.
Correct.
But that it was reduced is really the claim they are making in claim A. Because they are saying I did 24 lakhs worth of work. We have got paid 12 lakhs.
Yes.
12 lakhs is due. And that 12 lakhs is due because we have somehow illegally reduced the measurement. So this is really an overlap.
Yes.
And that's why it was not really argued seriously, I would hope. But that's E is really an overlap of their claim, A, B. A and C rather. B is interest. So if their case is that the measurement book was tampered with, and therefore our claim got reduced, but we have done work of 24 lakhs, you have paid us 12 lakhs. That's admitted here. Of course, with the 24% interest, they have come to 20, but it should come to about 12 lakhs principal. That will overlap with this 10 lakhs. No. This claim, damages suffered due to reduction in measurement and not recorded in the measurement book. So if their case is that I have done 24 lakh rupees work, and they have not reflected it.
That is covered A.
And if they have not reflected it in the measurement book, because we have paid according to the measurement.
Correct.
As it stands. Now they try to prove, or they prove that this measurement book, the correction should not have been included. Then their claim would still be 24 lakhs minus 12. So then how can they get this 10 lakhs? This is an overlap. This claim overlaps. If they are saying the damage they suffered due to reduction. So if the measurement book says 100 rupees of work was done,
yes,
and it was reduced to 50 rupees, that 50 rupees will surely be in their 24 lakhs claim.
Yes.
But even apart from that, as a matter of general principle on these two cases, I would say E and F, business loss and damages, cannot be done without proving it. So they will have to prove that this was the value of the work and it was reduced and etc. Now the Ahuja's case, Mala, that is in paragraph 15 of Unibro. I'm not repeating that. That's the base case, Mala, that says that they have to prove that they had opportunities, etc. My learned friend says that Bridgepal was cited by them. Of course, the principle they can argue in any event, but it has also been referred to in this Bartley Boy judgment in paragraph 13. They had relied on it. So it's not that this judgment has been passed in ignorance of this judgment. Paragraph 13, your lordship will see. In order to justify computation made by the tribunal, BEL has referred to Hudson's formula relied on by these judgments, in addition to the earlier decision of the court, A.T. Bridgepole, and few other decisions.
Yes.
Bridgepole, of course, talks about how damages are computed, but guesswork is really that 1963 Calcutta, where it says that the court can, there's some amount of guesswork can be involved.
Yes.
But that is your lordship applying your the judicial knowledge.
That's what I'm
to
telling.
do it.
If they prove,
Yes.
if they prove they are entitled, they're entitled for any business law, then the court can see yes what is to be.
So now. Yeah. Now, my lord, so as far as this damages and interest, my lord, then I will not make any further submissions. As far as this, the 12 lakhs that is due, now of course, Mr. Shah was making his submissions. I'll continue with that. I'm not going to repeat what he has said. If my lord comes to paragraph 36 of the plaint, what is their story? And I want to show from 375 the evidence.
36.
Yes, paragraph 36, page 24.
Yes.
21. 24.
Acha, running page 20.
21 also. Yes,
21 is the inner page.
Yes. So, in order to get the balance payment payable by the defendants within 31st March, following the usual practice, on 30th March 1996, the plaintiff, through its agent, sent an advance money receipt to the executive engineer at Kontai and of the defendants an undated receipt in duplicate containing blank spaces and addressed to the executive engineer, the following contents of which were as follows. Then they've set it out here. Now, this document has been just pleaded. What was this document that was sent? They have not kept a copy of it. Your lordship, this is just pleaded that we sent a blank receipt. Our blank receipt looks like this, but the blank receipt's copy was not there. So, according to them, now at page 94 of this compilation, this is the document. Original document is the exhibit. The exhibit.
Exhibit আছে সব ওখানে।
This
is exhibit.
So their cases that this document at 94, that's their prayer A, is a forged document. But they say themselves that they have sent this. Now it's written there.
Which paragraph you are reading? Which page?
Page 94.
94.
PD 40. It's also exhibited. I'm sure the exhibit, your lordship it'll be proved more whether
exhibit.
PD 40. The typed page is on the right side. I don't know if my lord has.
94 is different. Pagination is not telling. That's why Mr.
7 and 142.
Now that's why Mr. Shah has taken so many times. He told that he will give the compilation with all documents. Then he went. Then he come, argued some other point. Then he went. That's why this court has not granted adjournment.
142, I think.
None of the pagination is
92
matching.
to 94 is PD 40.
Give exhibit though.
Yeah.
PD 40 is exhibit double D.
Exhibit double D. So you are taken note of
Yes,
this.
yes. We had both taken inspection and Lordship was.
Twice I
pleased.
granted time
Liberty
because
to take
none of the pagination is matching.
And Lordship, every time I was placing
No,
the
the
documents,
last
I had to
hearing
show
I
it
saw
from-
was in April.
Correct.
But the scope is, which I think we have all spent your lordship's time telling your lordship the scope is very small. But we are not being able to finish it. This,
It's 30th March though.
Hmm?
30th March.
was here the received rupees such and such 12 lakhs 53,052 only against the noted work in full and final settlement of all demands. So they are saying this is forged. This line in full and final settlement is forged.
This is exhibit?
Yeah, double D.
No.
No.
No,
If you
no.
document PD টা বলো তাহলে
PD 40.
PD 40
That is CC.
CC.
Exhibit CC.
CC. PD 40 is.
So this is the document. They want a declaration, but the evidence that they have given. Now, as far as final bill and the supplementary are concerned, I want to place certain questions and answers from the defendants. So that is the document. I am saying that the figure in the document that we have paid them that figure is admitted. It is only that they are saying that
Yes,
no, we have additional.
Yes, they have admitted 12 lakhs.
To reach that, they have to challenge this document. So
That's
they
why
have.
the other 12 lakh they have to prove this is the extra work which they have claimed, but the department, after correcting the measurement book, they have corrected this and given the 12 lakhs.
Lordship, the issues I had invited your Lordship's attention to the issues.
Yeah, that is
The
it.
Lordship, my learned friend will indicate which issues he's.
Kindly come to the issue.
I'm going claim wise, it will cover everything, but I don't have the issues. I found this was my learned friend told Mr. Shah this also. I've seen the video.
It is there.
Yeah, I'll see. I'll come to that. If my lord comes to these some questions, my lord, from question 375
of PW1
of the PW1. Yes.
PW1. Give the PW1.
It's in cross-examination though of the plaintiff's witness.
He was a partner.
Lawyer দিতে পারে
Lawyer না, partner. 373 বলে।
lawyer partner নির্মলেন্দু দাস
কখন ছিল contest? That time.
PW1.
97.
$375 then final settlement and supplementary bills. I'll just come to that. So 375 if I may begin. Did you receive the full amount as per contract agreement? No. Whether as per tender agreement, did you receive the full amount of 12 lakhs 95,000? The tender was for that value.
Yes.
It was never stated rupees 12 lakhs and odd in the agreement. I believe the amount was higher than that. If I may see the tender, I can indicate. Is it 1253, etc.? In the work order, the amount of rupees 12 lakhs is mentioned, against which I got 7 lakhs and odd approximately. Thereafter, we had executed several other works against which we received no payment. So this 7 lakhs comprises of 554 about he has said and 2 lakhs something. And the rest was adjustment of materials.
Correct.
But in the plaint, that's why that paragraph 57 is important. There's no dispute on how much they got. The contract was for 1253, they've got that. But they've got 1253. Then 378. On the last occasion, when the full payment was made, did you receive the balance amount? I did not get the balance amount at the time of full payment. I did not get the amount either per work order nor per original execution of work. Do you want to say there is still a balance that remains to be paid? Yes. Then out of 12 lakhs, whether you've received the full amount. As far as the original agreement in the tender is concerned, which was for 12 lakhs odd, I have received payments in 2 installments. First for rupees 5 lakhs odd and then rupees 2 lakhs odd, totaling to 7 lakhs. it shows that you have received the amount. What does it say? The paragraph 40 of the plaint was showing. I am not talking about deduction in respect of materials. And then my thing is very bad. But basically, like I told my lord, 7 lakhs is the cash and the rest is for deduction. He's admitting that up to 1250.
Well, is admitted.
Yes. Then whether this is whether it is not within your knowledge that these deductions were in respect of materials given. It is their internal calculation. But in the amount shown, which was due from the respondent is 1253, has been deducted from that. What do you say? This figure includes departmental material, supplied, sales tax, income tax. So it's admitted. Then I put it to you that it is obligatory on the part of the contractor to write full and final settlement in the final receipt as per the CPW code. I disagree. I do not want what has been written
in the
CWT code. The work we have executed falls under the irrigation department and is not guided by this code. And this statement you are making from your knowledge, yes. Then as per the tender agreement, 1253 is the total claim, and in the total claim, 180,512 was the amount of extra work. What do you say? There are several figures of extra works, namely 5 lakhs odd and another for 90,000 and odd, while another was for 45,000 odd. Well, these figures, he has to prove that this work was done. Then if he says there is no agreement, of course, under section 70, he can claim if work was done. But my submission is that he has not proved that these works were done. Those items were not approved by the government, but only these extra works which were accepted by the government and included within the total tender amount. I never received any letter which shows the figures, namely 180 was approved by the government. Then, my lord, this 388 was shown to my lord on the last occasion, but I'm continuing because I want to show up to 401. 388, by the letter annexed at page 112, addressed to the executive engineer, you had made several claims for extra work. In reply, they have negatived your claims. Do you want to see the plaint? Yes. Then he sees the plaint. Question 390. Can you show any proof as to obtaining prior permission in writing for execution of the extra work from the executive engineer? Then he volunteers, but the answer is not very clear. I don't know. Your lordship has that answer to 390.
Yes, instructions were written down in the side book.
No, that is on the next page. But the last line of, I'm sorry to.
There was nothing in writing. Step witness
for execution of extra work from executive engineer. Then after
slash question mark slash there was nothing in writing.
Okay. There's nothing in. So he admits that according to us, the contract says it has to be in writing. So those are the suggestions from 391 to.
No. Yes.
391 to this.
No, that's why, because here this is the main case they have made out. They have executed the work as per the instruction of the executive engineer verbally, and this was noted in the measurement book, but subsequently it was corrected.
Yes, interpolated.
But as far as
so now whether that correction, because if why that has been included in the measurement book and how it has been corrected, these are the two questions.
Yes, whether this work that they are saying we did under instructions, whether this was reflected in the measurement book and we have tampered with it. This is the question that was fallen from my lord, and that I'm tell your lordship frankly today I can't answer that. Otherwise I would have wanted to finish it, but any other day your lordship says this is the point. And
this is the only, because see, in the contract work, as far as what the law says, in the you have also done the many arbitration work in the PWDs and all these things. The measurement book is the crucial document, because what happens in the general contract. In the general contract, it may be given for construction of the road 100 meters or 200 meters. But at the time of execution of the road by side, culvert or some extension or some path, something. So it comes excess work. So it is the purview of the executive engineer. He can say, yes, you execute, it will be included as extra work.
Yes.
So what is happening in the department? I am not telling this as experienced.
And then the measurement is jointly
Measurement, it will be done by the engineer in charge who available in the site. Contractor will be signed. What happens thereafter when it goes to the higher authority? Then higher authority will put some queries. Then case starts. The PWDs and CPWDs, the case starts from there only. When the matter goes to the upstairs, when they started querying and discussion, clarification, then
That is where the problem arises.
problem occurs. And with regard to the pre-receipt watch, the exhibit CC, but though they have not made out their case, I don't know. And exhibit CC, as per earlier provisions, initially, so the contractor has to give the pre-receipt.
Yes, Lordship. That is
Has to give the pre-receipt,
as per
and at the time of final, then it has to be in the recorded to receive full and final settlement.
So that is why, Bharat, that this is as a general practice, your lordship is perfectly correct.
That's why now
But
what
here in
they
this
have proved that they have to.
I'll come back for that short part. Then this case, there, if that work was just the same work but additional tar and cement was being used, then it comes under the measurement.
Correct.
But if it is a completely additional job, then it won't be measured.
Yes, that is
Then
not
their
extra
claim
work.
goes on the basis of the
Let us see what
their proof. So may I just complete this part as far as the final bill is concerned? From 388, I have already started reading it.
390, yes.
Up to 395, I want to place.
Correct.
So I'm at 391. Do you know that it is compulsory to obtain prior written order? There is no such instruction. So whether there's no such instruction to get prior order or there is no instruction to do it, I don't know. But I'm assuming he's denying that suggestion. Then is it in the tendered agreement? He had given me written instructions in the site order book, and the work was done in accordance with those instructions. What is the procedure for preparing the bill by the government or you? You yourself prepares and submit it to the government. It is recorded in clause 8 that the agreement that the contractor will submit its bill in a month, and if he fails, the department will prepare the bill, and the decision in this respect is final and binding on the contractor. This part of the agreement has gone through. What is the other? He said, I have only read this portion. Then 95. 395. I am suggesting to you that when there is no prior written order from the executive engineer to execute extra work, no extra work could be executed by you. So this is our case specifically. I'll have to show
He denied that.
395. The final bill is for how much? I couldn't make out things.
12 lakh something. Why I say so? Because from here it's 12 lakh something. 12 lakh 4,000.
केटे दिएছে
12 lakh 4,000 again at 851. Then it was carried on final here.
So this final bill, my junior man points out, is at page 610 on the right side. The numbering is the 610 to 614. এটা কি ওকে দেখায়নি? Is it?
393.
is done. I've read it. Okay. We built together. That's If my lord comes to this final bill,
yes,
my reading, my lord, again, I'll say this subject to correction that this bill is for 12 lakhs odd. It is not for 24. And that supplementary tender was a separate claim altogether. If my lord sees from 610,
yes,
it's a running bill at page 612. Bottom. I don't know if my learned pen has shown this bill. We might be clearer then. The bottom figure comes to 12,04,851. right at the bottom. At page 612. Your Lordship has total. It was 12.6 something, now it's become 12.04.
612.
12.0485, yeah, 612 page. Right at the bottom, the handwritten total. Two figures are scored out, and then the last figure is
8,56,728.
no, here right at the bottom here, just below the table. 612 in my
612.
yes. Page
612
number
handwritten.
Handwritten. 613 contains their signatures. Your Lordship sees the one page before that. Oh, amount.
There 613 1204 851. That is at 613.
613. Yes, that figure, my is blank. This is the 2 lakhs were paid. This is the memorandum. But I will not waste my Lord's time. I'll come back on this, only on this final bill point. These 2 points, I've completed my submissions. The damages and interest on compound cannot be given. And as far as this is concerned, my case is that without prior instructions, this work supplementary tenders could not have been part of this. But as far as the figure to correlate this with the measurement book changes, well, that I'll need at least some instructions from my.
That is the only crucial.
Very well. I'll
See, with regard to what you are showing, the 610 to 613, that is the bill prepared by the account section on receipt of
and it's signed by them.
No.
It is signed. That 612, it is signed by 613 is signed, 14 also is signed. The payment they received, 2 lakhs they received, and 7 lakh for 4 or 5 lakhs they received.
Yes, payment they have signed. So only you have to clarify with regard to whether that measurement book.
So those supplementary tenders is annexed to one of their letters. I think it's KK, Exhibit KK. Then, my lord, that supplementary tender, what has fallen from my lord, whether those items which they are claiming, which we are saying is comprises of this 12 lakh claim of theirs, whether that was the one that was subtracted.
Correct.
I'll have to show that.
Yes.
And my evidence that there was no, the person involved, the corrections were made. He had no authority to do that change. And they have produced their letters, but they haven't called him as a witness. They have given 2 letters.
He passed away. He died.
Oh,
he passed away.
He didn't come.
In fact, his signature has been identified by the defendant's witness.
No, he has dealt with my report. The department's report says that he has done this. So there's no dispute that. But the amounts, whether which should be the correct amounts, there is no real evidence given. It's all based on the demands and the letters. Someone should have said that this is the work I did, or they proved that this is the work I completed.
You could have written prior to executing.
And then on the reopening any day, not the first 2 days, but any other day, or after the 6th.
I believe my learned friend is not reopening the arguments already. Because
only that
it has been
portion.
argued.
That portion. Because now the damage portion he has relied upon 2 judgments, and you have to satisfy whether there is any evidence with regard to that. We have not produced any document, whatever it is, as per their submission.
Yes.
Now only with regard to the correction part.
Lordship, with respect to that measurement books, because
Are you going to re-argue? Then tell me what you
Lordship,
argue.
the issues, Lordship will kindly consider the issue
Let
that
them give a note of what they've argued. I don't know what the hide and seek is. I don't know what is argued.
Considered by the taking into consideration the document and all these things.
Yes.
Correct. So that's why issue was correct. Now the court.
No, I will address the issues at the end. I have to. But if my learned friend gives a note, because whether she cited that case or not cited the case, then it would be easier. But
Lordship, Bridgepal has been cited, Lordship, long back I had cited.
So and so appearing for the plaintiff, so and so appearing for the defendant, counsel for the defendant as argued at length, but due to prosecutor time, Give the date. What time? Give the 2 dates so that can. 17, 18 February.
Very well.
At
We'll bring a
2
note.
p.m. At 2 p.m.
18th February
17th and 18th.
At 2 p.m.
2 p.m. So matter can be finished. Yes, next.
I'm great.
I appear for the plaintiff. There are 3-4 applications.
Which one? Item?
26 of the commercial list.
Commercial.
Your Lordship, I am for the defendant. My senior is on his leg for the court number 32.
What application you filed?
No, there are 3-4 applications. I'll tell you, Manoj. GA1 is my application for injunction, where I'm enjoying order of injunction. I'm the landlord in the property. The defendants are, I see it's an agency agreement. Agency has come to an end with regard to restaurant of Park Street. Now, this is
that one?
Yes, that. I'm enjoying order of injunction. Now, GA2, GA2 is for vacating of the order of injunction.
They filed.
They have filed. Because they say I have not complied with that 39(2)(a). I have not served within 24 hours. I have served maybe after 48 hours. GA3 is section 10 by the defendant. Stay of the suit because of they have filed a prior suit in city civil court. GA4 is once again my application. I say that the agreement has expired. They are enjoying my property. You running a restaurant over there and not paying me a single penny. So some arrangement must be made, but you cannot enjoy the property for a fee, and even not eviction, but you cannot enjoy the property for a free. I'm not admittedly not paying any money, so my money be paid. So this is the 4 application. Occupation, oh yes, whatever nomenclature. Something has to be paid, you cannot enjoy it for free. Now, I believe that GA3 is the demurrer application because section 10, that requires to be heard. So, that is the first thing. And my injunction is still 24th of December. That has to be finished.
Lordship, my learned friend has briefed you, Lordship, about the facts. Only thing he has not added that initially we have filed a title suit in the city civil court. Interim order was refused. We went to the appeal in the High Court. In the appeal, there was an order of status quo. My friend was notified, they appeared. Now, thereafter, they have come with this suit here on the same self property, same self parties. And what my understanding is concerned that the prayer and the relief which they have sought is identical and substantially both the issues are same. Now, in that appeal, which was disposed of by the Honorable Division Bench, because Lordship in the meantime has passed one interim order, giving them a protection of a particular portion of the property that I should not use it, it should be not used by anybody. So there is a padlock there. The Honorable Division Bench has observed that while disposing of my appeal and said that since they have got the interim protection, whatever is the fate, you go back to the city civil court and your injunction will be decided by the city learned judge there, 5th bench, and the matter is remanded back there. And injunction hearing has also started. And they have appeared there, they filed their opposition, they filed the written statement recently on the last date, and the coming 13 January probably. 13 January is the date for the further hearing of the injunction application, Lordship. This is the scenario. Here, there are 4 applications before Lordship. One is their injunction initially which they have filed, which he has already said that affidavit will be exchanged, Lordship. Now,
what injunction you have prayed in the suit?
We have prayed that they should not disturb my business there because they are claiming that that business is a principal and agent relationship. We are saying, if that is mentioned there on the nomenclature, but the intention is that the business cannot be there because that was my business prior to starting a business in the Park Street. I was doing the business of the same brand at Salt Lake. So this cannot be a relationship of principal and agent. We have taken this point there. We have said my relief that I am the owner of that brand. So these things have been decided there, Lordship. He has filed his opposition there, reply has been done. Here also affidavit will be exchanged. Second thing which is claiming that he is the landlord also, we have disputed there in our reply also, Lordship. Because two things which has been failed to produce. Number one, he has failed to produce a single piece of paper that this business which is claiming belongs to him. Prior to my coming to the picture, whether that business was run by him or not, he has not produced a single sketch of paper. We have produced a document showing that prior to that, we was running the same business at Short Lake, number one. Number two, he has also not produced, we have also challenged his now locals, they have subsequently we have obtained the information that he's not the landlord of the premise also. He is the trespasser there. Now we have raised this question, Lordship will hear us or because whether a trespasser can claim an occupational charge or not. That has to be decided, Lordship. So if Lordship will hear it today or if Lordship can we come back?
Come after vacation.
Lordship.
Only thing, my lord, this I have to because 3P. Now that reason is, my lord,
So
that
in all applications, pleadings completed.
yes,
all
yes. Only thing, my lord, is enjoying the property, not paying a single penny. He's running a restaurant. Now these 3-4 applications we are getting entangled. Now, because unless this section 10 is heard, my GA4, which is the payment for some occupation charges.
Come, I will take on. I am fixing a specific date. I will hear it.
But date and time will take me in February.
February. 1 month, what purpose?
January,
Can be normally in the list when it's generally qualified.
Normally, I will fix that. Again, the same thing.
Same.
You will say the story, they will say the story.
No,
then
we can come.
Story and content story will go.
This
is better, Lordship. Can you fix a date? I'm also
We'll
ready
fix
with
a
the
date.
matter.
So first I will take the section 10.
Section 10. That has to.
Section 10 I will take, and if court find that yes, it is the same, then you have to go.
Then I cannot proceed.
Naturally, the all application will
Yes,
not.
fails.
If it is found, it is not, then
Then the next.
Grateful.
That is
grateful.
When suffering for the plaintiff, when suffering for the defendant, full stop. It is found that altogether 4 applications have been filed by the parties in which pleadings have been completed. In view of the above, let all the application be fixed for hearing on 18th February at 3 p.m. 18th February 3 p.m. The counsel for the plaintiff submitted interim order granted earlier is going to be expired on 24th of December 2024. Accordingly, the interim order is extended till 18th February 2025 or until further order, whichever is earlier.
কবে আসবে 18 তারিখ
18th February
18th
at
February
3 p.m.
Same name, huh? HON'BLE.
Next.
May it please your lordship.
I am appearing for the defendant 345. This is my application.
Well, there are two applications pending, your lordship, GA1 and GA2, your lordship. GA1 is my application for injunction. Pleadings are complete. GA2, my lord, is my learned senior friend's application. Pleadings are complete as well, your lordship.
Order 7, Rule 11.
Order 7, Rule 11, your
Your
lordship.
lordship said that this has to be heard first.
My lord, this was never indicated, but be that as it may, my lord, we are willing to argue on this as well, lordship. Kindly allow my
I will only rely, my lord, on the plaint. My first ground for rejection and dismissal of the suit is, my lord, on the ground of revocation of leave under section 12 capital A. That the leave which has been granted under section 12 capital A is liable to be revoked, as the plaintiff read as a whole will show that it does not contemplate any urgent interim relief.
These are two, GA2.
This is GA2, my lord.
Yes.
But I will, I am just a 2-page list of dates only relating to this institution of the suit purpose. My lord, I have
number 3 and 5. You are for the 3 and 5.
3, 4, 5.
3, 4,
3, 4, 5. Another total list of dates. Please.
Yes.
But kindly take my list of dates. 17th, kindly see first this date, 17th October 2023, plaintiff affirmed a previous plaint on the self-same cause of action before the Honorable High Court at Calcutta. And before this suit, my lord, there was a plaint which was affirmed. 18th October 2023, the said plaint was filed and the suit was numbered as CS 231 of 2023. 24th January 2024, said suit came up in the list of Justice Arindam Mukherjee for presentation when the plaintiff withdrew the said suit with liberty to file afresh on the same cause of action. Kindly note. So their cause of action for the suit had crystallized arisen when they had affirmed a previous plaint on 17th of October 2023. They have voluntarily withdrawn it with liberty to file again on the self-same cause of action. I could have understood is a subsequent cause of action. Then, my lord, 1st of March 2024, plaint in the present suit was affirmed and it was presented, my lord, on 5th of March 2024. So, therefore, my lord, and 19th of March, next date, was presented before your lordship and leave was obtained under section 12 capital A. So, therefore, the question which arises is, my lord, if the cause of action for filing the suit had already arisen on 17th October 2023, whether there was any requirement to dispense with the mediation procedure and seek leave under section 12 capital A of the Commercial Codes Act. You know, October to March, the mediation proceedings would have fructified and one way or the other a conclusion would have been reached. So, my lord, this is my first ground, and now I show from the plaint how they are invoking the contemplation of urgent interim relief from the plaint. Now, kindly, the plaint is annexed to my petition. The plaint starts at page 12. Kindly come to paragraph 31 at page, running page 35. Cause of action of the present suit arose on the first week of December 2014, when the plaintiff made payment of 1,95 lakhs to defendant number 1 and 2 for the first time, and has been continuing day to day. Also on 7th May 2021, when the time period of 1 month for execution of deed of conveyance in respect of 3 kata land expired at 2242 capital A, Prabhupada Chandra Road, and subsequent thereto, after obtaining possession in the year 2022, thereafter, when the advocate of the plaintiff issued notice dated 10th April 2023, 3rd October 2023, for execution of deed of conveyance to defendant number 4 and 5 with a copy to the other landlord, but the same was denied by the defendants, cause of action is still continuing. So, my lord, if your lordship sees, the last cause of action pleaded is notice dated 10th April 2023 and 3rd October 2023.
Yes.
After which, the previous plaint was affirmed on 17th of October 2023.
Yes.
So, whatever cause of action they had, that culminated in their filing the previous suit on 17th of October 2023, yes, which they withdrew on January 2024. Then present suit on 5th of March. But in the 5th of March suit, this is the pleading of the cause of action, which shows that the cause of action is crystallized before 17th of October 2023 and they had filed that other suit. So, admittedly, on the reading of the plaint, it does not imply that the plaintiff had any, could have contemplated any urgent interim relief. Because my cause of action is of 3rd of October 2023. Yes. This is number one, my lord. There is one other now, how they have invoked the cause of action, the urgent relief here, that your lordship will kindly see. Yes, kindly come to these some facts which they are now pleading here. Yes, kindly come to paragraph 18, page 30. Kindly see paragraph 18. Plaintiff states that on and from the first week of February 2024. So this is what they are saying is after the first suit was withdrawn, January 24. So they are now trying to bring in from February 2024, plaintiff was confronted with unwarranted harassment from unknown identified men kindly note this.
Yes.
It is not the case that the defendants of this suit are interfering with their possession. From unknown and unidentified men with their sole or motive to dispossess him from the Schedule B property, such actions took place on various occasions thereafter. Subsequently, the plaintiff, while under constant threat of being forcibly evicted from the schedule by, again, my lord, kindly note, by local miscreants, lodged a complaint before the Bartala police station on 28 February 2024, elaborately intimating about the prevailing situation. Photocopy is annexed here too and marked as Annexure L. So, my lord, if your lordship looks at paragraph 18, my humble submission before your lordship will be this paragraph and the averments taken to be true and correct will not contemplate urgent interim relief against the defendants.
Yes.
And this is not a cause of action against the defendants. Because two places they have said unknown identified men.
Yes.
And even if your lordship looks at the complaint, which is part of the plaint, there is no allegation against my clients or any of the defendants. So therefore, my submission is the complaint on 28th February 2024 as pleaded in paragraph 18
Yes.
cannot give a cause for urgent interim relief for this suit. Then, my lord, kindly sees paragraph 19. In the meantime, plaintiff has come to know that the defendant number 10 has lodged a police complaint on 13th February 2024 before the officer in charge against 3, 4, 5, 7, and 11. So this is not the plaintiff's case.
Yes.
This is the case of the defendant number 10.
Yes.
Photocopy of the complaint dated 13 February 2024 is annexed here too and marked with the letter blank. Now kindly come to paragraph 22. It has come to the knowledge of the plaintiff that the defendants are trying to proceed with development agreement dated 10th September 2020 and trying to construct proposed high-rise multi-storied building by demolition of the existing structure over premises number such and such, even when the plaintiff is in due possession of Schedule B property of the plaint. Subsequently, plaintiff duly made inquiries before the departments of Kolkata Metropolitan Development Authority regarding any proposed project work over Schedule A mentioned property, to which Kolkata Metropolitan Development Authority issued notices raising certain queries and also intimating our prevailing situation concerning Schedule A property. Evidencing such attempts being made by the defendant for getting statutory clearance, and the reply notices are collectively annexed here to and marked with the letter P. So this has come to the knowledge of the plaintiff when it is not their case that after the earlier suit was withdrawn,
yes,
then this proceedings and these notices have come to the knowledge of the plaintiff. You have annexure P. And that too, my lord, if this is based on something else, then that they cannot take advantage of the liberty granted by Justice Mukherjee.
Yes.
That is on the same cause of action. It is like saying that I have pleaded everything in my earlier plaint. There are some technical defects. I just want to remove them. My cause of action remains the same. So therefore, we have to assume, taking their submission to be correct before the earlier suit court, that this cause of action was already there in the earlier case. If it is already there, so again, we have to start from the date of 17th October 2023. Nothing beyond 17 October 2023 they can rely upon having regard to the order of Justice Mukherjee. Similarly, if we take it that the plaint is the same, then they have stuck to that date of pre-October 2023. And from October 2023 to March 2024, the mediation proceedings could have been completed. So it appears that they have deliberately not taken recourse to mediation proceedings, and they have obtained the Section 12A leave without any pleading or contemplation being reflected in the pleading of urgent interim relief.
Yes.
My lord, if your lordship sees some of the documents which are part of Annexure P to the plaint, If your lordship takes the plaint নেই কেন যে প্লেন্ট কিন্তু অনেক প্লেন্ট উইথ অ্যানেক্সার্স এরকম মোটা কেন
তো নেই প্লেন্টের সাথে
क्या हुआ नहीं है
No, actually the difficulty I have annexed the plaint.
क्यों सूट हम तो बोलते सूट कोट सूट क्यों नहीं आता
Very well, my lord. I shall proceed on the basis of
directing. This is suit court and interlocutory court should be along with the interlocutory application. Every day in one or the other matter, this is going on. Yes.
Well, I'll because I will be citing first some judgments on the question of revocation of leave under section 12A.
My lord, the GA1 has all the annexures.
Yes.
I'll go to the so this is my issue with regard to the first point, section 12A point. The second point I will come later, but let me first finish the judgments on the section 12A point. এটা জাজমেন্টটা দেখো কোনটা দেখাচ্ছি আমরা ইয়ামিনী গৌতম না First, my lord, I will cite a judgment of our court, single bench, that the suit is liable to be rejected if section 12A case is not made out and it is permissible for the court to revoke the leave subsequently. This is reported in 2024 SCC Online Cal 1838. কোন কপিটা আমি একটা মার্ক করেছিলাম না হার্ড কপি ও yes পাচ্ছি না দাও তো Kindly come to my lord. Oh, sorry. Paragraph 8, first, your lordship will see. Issues which hence falls for decision are headlined below. Answers to the issues form part of the discussion. Can the dispensation granted under 12A of the Commercial Courts Act be subsequently revoked? If yes, can the suit be dismissed under Order 7, Rule 11 of the Code of Civil Procedure? These are the two specific issues, my lord. Then, my lord, 12A is quoted. Paragraph 10 deals with, my lord, section 12A makes two things clear. Suit which does not contain urgent interim provisions cannot be instituted unless the plaintiff first opts for pre-institution mediation before instituting his suit. Number C, the suit can, however, be instituted if the plaintiff obtains dispensation of the mandate of section 12A time of institution. In other words, the plaintiff must establish and the court satisfied on such showing that the plaintiff requires urgent interim relief and the urgency will be frustrated if the plaintiff is relegated to mediation. This is important. Urgency would be frustrated if the plaintiff is relegated to mediation instead of pursuing its urgent interim relief in the suit. More significant conclusion from a plain reading of section 12 capital A is that contemplation of urgent interim relief under provisions of 2015 Act is a matter which is to be determined at the time of institution of the suit. Contemplation is not one which the plaintiff can reserve for a later stage for the court to examine. Specific words of section 12A are such and such, meaning thereby that the plaintiff cannot institute a suit which does not call for any urgent interim relief and keep the suit alive for an opportune time to argue such interim relief. Mandate of 12A of the pre-institution mediation in the absence of any urgent interim relief becomes even more clear from the words, a suit which does not contemplate an urgent interim relief shall not be instituted. Hence, the plaintiff does not have the option of any later or subsequent contemplation of urgent interim relief post-institution of the suit. To reiterate, one last suit which does not contemplate urgent interim relief shall not be instituted without resorting to pre-institution mediation period. Who decides contemplation for urgent interim relief? Since carriage of proceedings with the plaintiff, the onus of proving there is indeed a case for urgent interim relief rests squarely on and must be discharged by the plaintiff. How can the plaintiff do this? Then, Malad, I am not placing all this. Your Lordship can straight away come to. Yes. Now, this paragraph may be important if your Lordship sees paragraph 16 once. Court receiving the plaint and considering grant of leave for dispensation of the requirement on 12A of the Commercial Courts Act is also clothed with power to decide whether the suit contemplates urgent interim relief at the point of institution. In other words, the contemplation under 12A is not the sole domain of the plaintiff, but a multi-decision domain where the court also plays its part in deciding whether the suit contemplates urgent interim relief and whether the plaintiff should be granted leave to institute the suit without exhausting the pre-institution mediation option. That is the Supreme Court view in Yamini Manohar. Onus shifts to the defendant subsequently to establish that suit did not contemplate urgent interim relief at the time of institution. The court will then examine the case brought by the defendant in considering whether dispensation of the mandate under 12A was wrongly granted. This is what we are trying to do. It is also relevant to state that grant or refusal of relief is not relevant for deciding the issue of urgency. Court's finding on urgency is, however, of paramount importance. This is precisely where the second order dated 19th October 2023 comes to the fore. Here, my lord, initially an arrest order was passed and that arrest order was vacated on the ground of lack of urgency. That is why the court is saying findings of the court for vacating the order of arrest have been dealt above and are not being repeated. Suffice for it to say that the case sought to be made out by the plaintiff for urgent interim relief at the time of presentation of plaint was demolished at several levels. Court specifically found there was no urgency pleaded in the plaint or otherwise shown by the plaintiff. Further, even if urgency requirement was discounted, plaintiff's maritime claim could not have travelled with the vessel since the claim was restricted to the erstwhile owner. Second finding was based on Admiralty Act. Paragraph 20 is important. Most significant finding, however, was that the plaintiff was unable to show any compelling intervening facts after withdrawing two earlier Admiralty suits and instituting the present suit. That is between July 22 and October 23. This is where I am coming in. The order further records that neither the plaint nor affidavit of arrest contains any specific pleading as to why facts suddenly became time sensitive, warranting an ex parte order of arrest. My case also, I will rely upon your lordship's order. Your lordship declined ex parte ad interim order. Other facts which were this, then it is not necessary. Kindly come to paragraph 25. Clause 12 of the latest patent authorizes the Chartered High Court in excess of origin to receive, try and determine source of every with the cause of action as the arisen, either wholly or in part within the local limit. Plaintiff is required to obtain leave. Defendant can subsequently pray for revocation of that leave on the ground that no part of the cause of action has arisen within territorial limit. The court, on weighing the competing case of the plaintiff, is empowered either to revoke the leave,
may I be lordship's leave,
or reject the defendant's application for revocation. Power of High Court to grant dispensation of the requirement on 12A of the Commercial Courts Act is on a similar footing and conferred by the Act. High Court is hence entitled to revoke dispensation granted under 12 capital A. Power to revoke the dispensation granted 12 can be made even suo moto without being tethered to an application made by the defendant in that regard. So this is the first proposition, that court which grants leave under 12A has the power to revoke it. Then, my lord, the second issue, can Order 7 Rule 11 be pressed into service on a subsequent no urgency finding of the court? So, my lord, your lordship will kindly see paragraph 28 that deals with the Patil Automation judgment, provides for rejection of plaint and dismissal of the suit on several grounds, including that the suit is barred by law. Therefore, if the court comes to a specific and subsequent finding, either suo moto or an application made by the defendant that the suit did not contemplate urgent interim relief at the time of institution, court is entitled to dismiss the suit under Order 7 Rule 11D, barred by law, that is the suit contravened the mandate of 12A of the Commercial Courts Act. To repeat, 29. Institution of a suit which does not contemplate urgent interim relief without exhausting pre-institution mediation under Section 12A falls under statutory bar under Order 7 Rule 11D. Statutory bar would hold good even if established at a stage subsequent to the institution of the suit. This is important. Court can hence treat the contravention within the fold of Order 7 Rule 11 and proceed to dismiss the suit. So, my lord, this is the provision, my lord. Ultimately, my lord, the conclusion your lordship will get at paragraph 38.
Yes.
Dispensation under 12A granted to a plaintiff without exhaustion can subsequently be revoked. Revocation of dispensation under Section 12A is akin to revocation of leave under Clause 12. Revocation of dispensation can be on application by the defendant or by the court on its own motion, on the court being satisfied that the suit did not contemplate urgent interim relief. And if it is revoked, then the plaint in the suit can be rejected under Order 7 Rule 11 if the court finds that suit was instituted in contravention of the mandate of 12 capital A.
Yes.
And paragraph 41 also your lordship will kindly see. 40 and 41, the plaintiff's argument that contemplation of urgent interim relief may revive post-institution of the suit or even at the stage of trial is without statutory basis. It has to be on the date of institution of the suit. You have to contemplate that today I am contemplating.
What is your urgency?
Yes. The words in section A make it clear contemplation of urgency begins and ends at the point of institution, that is material point of time when contemplation must fructify into a proved and pleaded case for urgent interim relief. Hence, allowing the suit to remain in the records despite an absence of urgency on the contingency that urgency may arise at a later point is patently contrary. Moreover, the words urgent interim relief by its very definition means relief which the plaintiff seeks at the interim stage and one that cannot wait for a later adjudication on affidavits or at the time of trial. It stands to reason that the plaintiff would be under an obligation to explore mediation as an alternative dispute resolution mechanism before institution of the suit where the plaintiff does not need such urgent interim relief. So from October, you could have exhausted the remedy of mediation, and by March, it would have been over one way or the other, and you could have filed the suit. So, my lord, so therefore, my lord, my submission is on the pleadings of the plaint and the fact that the earlier suit was withdrawn with liberty to file afresh,
yes,
would show that there was at all no urgency to dispense with the requirement of mediation.
Yes.
But I am not formally citing that Yamini Manohar, but I am keeping it for your lordship's records, which describes or elucidates what is the contemplation of the plaintiff, what it means. Well, particularly, well, the paragraph.
Well,
I'll just give your lordship the paragraph number.
Well, I think
9 and 10. Your lordship has seen it so many times. There's no point, my lord, wasting your lordship's time by just reading it. My lord, the other point is no cause of action disclosed. Should I, because it is 3:30. Next day, I will just take 5 minutes for this non-disclosure of cause of action, and my other side can reply.
So and so appearing for the plaintiff. So and so appearing for the defendant number 325.
6 and 11. 6 and 11.
So appearing for the defendant 1, 2, and 9.
1,
2, and 9. So appearing for the 6. 6 and 11. So 11. So 7. 8. Full list. The counsel for the defendant number 2 has filed an application being GA Com 2 of 20.
325 has filed.
325. Defendant number 325 have filed an application being GA Com 2 of 2024, praying for revocation of leave and rejection of plaint. Counsel for the defendant number 325 has argued at length, but due to paucity of time, hearing could not be completed. fix. Give the date. December.
9/2. Huh?
Since it's going to February, my lord, may I pray for a 12 o'clock or a 2 o'clock?
I will keep at 5:30.
And my leader will also, my lord, will argue. No problem, my lord.
Okay.
Suparna ji.
5:30. Morning.
No.
Morning. A fresh mind. 19th February at. Give 2 dates. It we can.
So that can be fixed.
19 and 20 February at 2 p.m.
2 p.m. Obliged.
My lord, may I be permitted to mention argument item number 86, my lord. And it may be taken on Monday any time without lordship.
Come after.
Extension of interim order
Only interim order which
expiring today, my lord, will kindly.
item number?
My lord, this is. Give me 1 second, my lord.
Skipper.
My lord, it's running in the list. My lord, this is item, my lord, 81. OCD 81.
81.
Yes, my lord, I've served notice.
Commercial matter.
Commercial matter.
Commercial 81. Let me see. 81, huh? Sense appearing for the plaintiff, not defendant.
My lord, I've given notice, my lord. Mr. Rituban's shortcut was appearing. I've given notice, my lord. Email me.
Plaintiff has issues served notice upon the defendant for urgent mentioning, but none appears on behalf of the defendant. Though the matter is listed as item number 18.1 in the today's list, but due to paucity of time, the matter could not be taken up for hearing. Counsel for the plaintiff submit that interim order granted earlier is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 24th of January 2025 or until further order, whichever is earlier. Let the suit be remain in the list.
Lord, before your lordship rises,
kindly to mention about
345 matter fixed.
Yes, he is mentioned.
Yes. Page.
Well, the same matter, my lord. 345, your lordship was pleased to fix that matter.
Item 10.
Yes.
10 of today's list.
Yes.
Yes. It was fixed today at 345. Since it cannot be taken up. This is the second round, if your lordship recollects. There was an appeal court's order pursuant to which, my lord, we have filed our affidavit. I am for the defendant number 6.
Yes.
And your lordship was pleased to fix it today at 345. Cannot be taken up. So any day, my lord, convenient to your lordship after reopening.
Item number 9.
Item number 10. 10, my lord. Item 10.
You are appearing for?
My lord, I'm being led by Mr. Post.
My lord, defendant number 6.
Who is for the plaintiff?
I'm for the plaintiff.
So appearing for the plaintiff.
I'm for the defendant number 1, 2, 3, and 5.
So appearing for the defendant 1, 2, 3, and 5.
Lordship, I appear for defendant number 10.
So appearing for the defendant number 10.
Lordship, I appear for 11 and 12.
So appearing for the defendant number 11 and 12. And so appearing for the defendant number 6 and 7.
13, 14, my lord, I also appear.
So appearing for the
after defendant number 6, my lord, appearing from London.
Defendant number 39.
14, my lord.
14. I will declare, he will record. And it cannot be deleted as the virtual mode.
Yes.
So, yes, what you are doing?
I want to file affidavit in opposition.
Of?
In respect of what? Affidavit.
Counsel for the 1, 2, 3, and 5 has
to be allowed to file an affidavit in opposition for 11 and 12.
Counsel for the defendant number 1, 2, 3, and 5, as well as defendant number
11 and 12.
11 and 12 had filed their affidavit in opposition after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record. Full stop. Counsel for the plaintiff and is liberty to file affidavit in reply within a week after winter vacation. Full stop. It is submitted that the interim order granted earlier is going to be expired today and prayed for extension of the interim order. In view of the submission made by the counsel for the parties, counsel for the plaintiff, the interim order granted earlier is extended till 21st of January 2025 or until further order, whichever is earlier. Let the matter, say to fix matter, hai na? Let the matter.
May I just say one thing, my lord? May I just say, my lord, your lordship was pleased to fix pursuant to the appeal court's order. Appeal was by the defendant number 6. So the direction upon defendant number 6 and the plaintiff was peremptory for filing affidavit. So that was completed. That is the reason your lordship was pleased to fix it today.
देखो
Well,
345 को भी डेट देखो.
any day convenient, your lordship was the after you.
मतलब मेरे दाना ना देखते थे. PM देखो.
Not report that कुछ नहीं है. 345 full.
My lord, but the Chief Justice's, my lord, the calendar is also not as full as your lordship's. Yesterday I had logged in to do a matter before the Chief Justice. So the matter, there were too many counsels in the matter. So everybody wanted the matter to be fixed. So the judge said that very well, on any day next week, because the non-miscellaneous matters are taken up on Wednesday and Thursday, so it will be in the list and no adjournment will be granted. And it will be amongst the first 10 matters in the list. The moment he said that, everybody wanted a different date.
19. Huh? 14 January 3:45 PM.
About Friday na?
Friday.
2 PM.
24, not 14. 24 January 3:45.
Interim order, your lordship is extended till 21st. So
21st.
if it could be 2 or 3 days after.
Okay. 21st na, and the interim order bola 21 na, extended till
So,
20.
my lord, make it to 15. It will be better. So
that's
that
not-
urgency will. My lord, your lordship has been pleased to fix it on the 14th.
Yes, not 14.
24th.
14 is vacant.
No,
vacant.
24th, my lord, will not. 24th is a Friday, my lord. Friday. Between the 23rd to 20th.
My lord.
Not on Friday. That, my lord. Kindly any other day, barring.
And I am sure Mr. Gupta will not be.
I'll not be here.
Virtually on the 24th. Yes, I can imagine. Being a long weekend and the number of farmhouses he has. So, I mean, he has to attend one every long weekend.
कब रखेगा? आई नहीं.
Anytime, around 12:30, 4, 1 o'clock, 2 o'clock, anytime.
It's on. Since when you will not available?
But only 24th I am not.
24th you will not available. 21st of January. 21st January at 12.
21st Mr. Thakkar.
Duly obliged, my lord.
My senior Mr. Thakkar won't be there on 21st.
No, let us finish now. We will argue. Thereafter they can argue.
21st and 29th.
Okay, कब February क्या बोला? 5th February at 3:45.
The interim order.
Interim order 5th February. Yes.
Malad is keeping it on the 5th. Malad,
yes.
No earlier date is available.
What is the problem?
21st was the right date, but what I was submitting, let us finish, then Mr. Thakkar can reply on the next day.
Yes.
You will be available.
Because they are enjoying an interim order, I have to address your lordship.
But we have to start. So it's our application after
How can you start? You are enjoying an interim order. You cannot start. I have to start.
Have you filed an application vacating?
No.
Affidavit
it's
complete. Affidavits are complete.
So it will take time.
Yes.
It will take some time.
2 days.
21st. Well, it doesn't. It's a short matter, but your lordship has already extensively heard it.
It's not a short matter.
He will be available when? 17?
Yes.
17 at 12 noon.
Obliged.
17 January 12 noon. Interim order extended till 21st of January 2025 or until further order, whichever is earlier.
Leave to use a supplementary affidavit, which in extreme haste we couldn't do with the affidavit in reply.
You come, what are the documents? Let's see if required, then we'll see to that.
Well, 17th was the only day I'm not available.
I also let it be on 5th, your lordship.
Let it be on 5th of February, my lord, then.
5th of February.
Yes.
Now, may I just say this, my lord? Let it be on the 21st. If Mr. Thakkar is in some difficulty, my lord, I will complete. Then they can again.
Yes, indicate that he won't be there on 21st and 29th.
21st and 29th.
Yes.
He will be not available.
He will not be.
24th.
24th, my lord, is that weekend where.
Achha, you will not be available.
My
28.
Yes.
28 kori then. 28 12 noon. Correct.
Great.
And interim order till 28.
Great. Okay.
Or until whichever is. Yes. Next.
Grateful.
May
And further.
I pray for my lord's leave, my lord, to file a written statement. This is, my lord, within 120 days, but my lord, outside of the prescribed time. In the
within 120 days.
Yes, within 120 days. We have filed an application for extending the time.
How many days?
But this is my 27th December, my lord, is the 120th day.
Give. Leave is granted. Leave is granted to the defendant to file written statement in the department. Today you will file.
Not by Monday at least, my lord.
And by 23rd of December, subject to acceptance by this court.
Grateful, my lord.
No, not.
Say the vote.